All right. The first thing that I think we're agreeing upon is that we must separate the 90-10, which are policy matters from contractual matters, multi-choice and others. And we're just trying to, Honourable Swartz, because you're the last, you want to still talk on these matters? Just one? Okay, Swartz, Honourable Swartz, you'll be the last one to try and help us. We're now separating the contractual, we're just talking now on the policy. And maybe we shouldn't just limit it to the 90-10, because I mean there was policy on, there was all sorts of editorial policy and all those policies. The good news, all those things were policy type matters. So maybe that will help us in saying what was the observation around those matters. Because I agree with Honourable Swartz, because once you pointed at one instance or one individual, you open up yourself more. But generally speaking, this was our observation. And we can defend it if we needed to defend it or whatever the case might be. So I'm directing members now to talk just on policy matters, not on contractual matters. Dr. Khoza, and then Waters, and then Swartz, jy gaan ons help, meneer. Dr. Khoza?
Chair, I wanted to recommend that maybe we consider saying regarding the 90-10, editorial and related policies, there doesn't seem to have been sufficient consultation and adequate due diligence paid on the financial implications of such policies being implemented, or something to that effect. But we need to, the point I'm more worried about is that let's not leave out the financial impact, the negative financial impact of the rush in the implementation of those policies.
Chair, with regards to the 90-10 issue and Parliament applauding, I mean, I can't find it in their report, but maybe we could be referred to it. But Parliament applauding a certain policy doesn't mean it was consulted. It could have just been informed, quite frankly. You know, and so there's a distinction. And so I would like, I don't know if Honourable Swartz could draw attention to where it is in the report, because I can't find, I was trying to look for it. Where? Page 4, on the beginning.
Page 4 of which document?
The SABC report. Let me just see, thank you. You see, they don't say the consulted Parliament, they just say Parliament applauded it. So there's a distinction, and I think, for me, I'm not a lawyer, like Honourable Swartz, so, you know, but the fact is, I think we should keep it in. That's my view. And the other issue about the 70-30 issue, I think we need to specify that as well, and make it saying, and other, as it's been mentioned, other editorial policies, and I think in brackets the 70-30, because that's very important. That was something that was used during the election campaign, you know, the positive and negative side of things. So I think, and also the issue about not airing any violence on the news bulletins. So I think we should say the editorial policies as well, because we need to look at that. Yeah, I'm supporting you. Okay, but I think Parliament should remain in that sentence. Thank you.
Honourable Swartz, we're hoping that you've followed us. We're dealing just with editorial policy. You've heard what Dr. Khoza said and what other people have said. In light of what you raised from where you are sitting, what are you suggesting we do, sir?
I like the suggestions that have been made by Ms. Killian, by Dr. Khoza. The only reason I raised it is so that any persons reading and listening will know that we are taking seriously what the SABC has said. Doesn't mean we accept what they're saying, but we are considering what they are saying. And I fully suggest, I support the views of the committee that we capture it as they have suggested, Chair. So I think the point is well made that we are considering what has been said by various, whatever the submissions are. And that is our duty when we make findings. Thank you, Chair.
All right. Cindy is indicating that she thinks she's got the essence of it. We will try and get it out, and of course, you guys will doctor it later on. I beg your pardon?
Chairperson, can I email what I've read into the...
All contributions are welcome, but at some point before you sleep tonight, you'll get a document of what has been discussed, so that, remember, tomorrow, go through the whole document, adopt it after we've cleaned it up, because we can't have this exercise tomorrow and meet the deadline. So before we sleep, Cindy and I will give you some document, and everybody else. Yes, sir.
Take all the amendments will be underlined as normal, so we can go straight to them. Thanks.
All those that are underlined up to now will be de-underlined, for want of a better words. New ones will be underlined. Okay, that spoke to the policy. We were not clear, unless you've captured it. We were not clear in terms of the observations on the contractual, vision high, it's not vision high, vision something, multi-choice and all the others, because initially when we started, members said we must separate the two. What are we saying about that? Mahlangu, Killian, please put your mic off.
Chair, with regards to the entities that you are referring to, the companies, I think on page 73, clauses 24.2, 24.3, sorry? Oh. Of the same document? 73. Yes, they are appearing there. So I think, unless if we want to remove them and put them, oh, no. These are now, yeah, they actually fall under the, what is called suspicious transactions. So I would think that we should retain them there and not include them in what we have just been saying. Otherwise, then if we bring them there in here, then we must move them to the other side. I think we rather keep them where they are and have the ones that are actually referred to in that. That would be my view.
All right. Remember, honorable members, we're dealing here with the duties of the board, in essence. I think your point is valid, because unless you're saying the duties of the board or lack thereof created the scenario, then they will fit into both. But what Honorable Mahlangu is saying, they're better placed in the, what we've got, for want of a better word, suspicious contracts for now, in terms of the contracts. Policy we're all in agreement with, because it's, as the accounting officer, they should surely be responsible for policy. So could we take the multi-choice one out and everything that we've said? Because that's what Mahlangu is suggesting, honorable members. Killian.
Chairperson, I would have wanted to do that, but remember our heading here is very specifically, and it relates to the failures of the board. So I think we're going into the detail of suspicious transactions, but that is for follow-up further. We have not made a determination and a sort of an observation, and therefore I would suggest that we actually keep it here, but we just have it as a separate section. And I would like to just sponsor it to say a general culture of non-compliance with sound financial management principles and supply chain management provisions existed when agreements related to the multi-choice deal, Vision View studio upgrade, and other questionable transactions were entered into.
Were entered into, and I guess what you're saying, Killian, is that the accounting authority didn't do what it was supposed to do. So you can't just say we're entered into, you could say we're entered into where we expected the accounting authority to...
I will add such a sentence.
Because that's the observation that we are making.
That's the observation. In other words, we can also introduce it at the beginning to say the accounting authority did
failed
not...
whatever the case may be. Yeah, but we've got to say that, because we're talking about the failure or otherwise of the accounting authority at that point. With us, honourable members? So then we separate that from the contractual and the PFMA or anything else. All right. So in terms of the fiduciary duties, what we are saying is that the board didn't do what it was supposed to do when it came to policy, and we've discussed the policy. The board didn't do what it was supposed to do, in our view anyway, when it came to ensuring sound financial management, because that's their responsibility. So we'll couch it in that fashion. We're still on 2224, Honourable Doctor. If you want to sponsor it for us, that helps us, but just on those, ma'am.
Chair, no, I was just wondering, where do we place, because I do think that it may fall under the fiduciary duty as well, the issue of the failure of the board to implement the public protector's remedial action. I don't see it, Chair. Where is it? Yeah, I thought that we should have a bullet point that speaks specifically to that, because it's been a matter that's... I don't know if it's covered.
No,
somewhere,
keep
but I
it, yeah.
don't see it.
Oh, it's fine. Because remember we said we'll go through what we have currently and we'll add to it. If it's not there, we'll add to it. We're still on 224, sir. 2224. Now I'm looking at Prof. Kubisa. Are you still on that one?
Chair, I wanted to speak to the public protectors issue that is covered on page 73, but we can keep it in mind as well.
What Doctor is saying is that even if it's covered under page 73, we must also cover it under the failures of the board to implement. I don't know if you want to have it on board. That's what Doctor's...
No harm, Chair. No harm.
Eh?
To repeat. It's an important issue, I think.
We should put it on both of them.
Public protector.
All right? Happiness? We'll put it as the last bullet point, 2229, Cindy. All right. Honorable Killian, are you suggesting that you are going to sponsor that 2224, including, focusing on the fact that the accounting authority failed? All right,
I've rewritten it to that effect.
And taking out from sound to agreement. That we've got. You just sponsor the rest. Okay. It's a bit more complex than we expected, but on Salapi Fanand. Anything else on 2224? No? Thank you. 22, can we go to 2225? 2225, and I'll always remind you that we're dealing with observations, we're dealing with findings, and we're dealing with the performance or otherwise of the board. I'll keep on keeping you to that border, not anything else. The board did or didn't do, and so on. So I want to check if anybody wants to change 2225.
I think maybe, I don't know, I'm just suggesting that we delete the first line, up to, the committee concurs with former board members that, and we started this sentence that had board members been inducted into the new roles upon taking office and received whatever, that sentence. The reason why I am saying that, I don't think that's the view of all the board members. That, they would have, all the board members are saying, because it's like nobody's taking responsibility now, it's because we're not inducted or whatever. I don't think that's what we are also trying to say. I would rather say, because this is our finding, that we delete, that the committee concurs with former board members that, so we delete that. Yeah. Had the board members been inducted into their roles or upon taking office, and received training with regard to their respective roles and many of the challenges may have been averted as our finding.
You'll come back and defend it after members have challenged it, if there are any, but I see Singh, not
Yeah,
necessarily
yeah,
challenged, but after
Yeah,
Singh's
Chair, no, I'm
comments.
not challenging the principle of Honorable Causa, but maybe we could say the committee is of the view that had board members, we don't have to concur, but is of the view that.
Anybody else on that point? We happy? Thank you, you've got that. Yeah. From the kingdom, I'm worried about these people from the kingdom. Obviously, Cindy is whispering in my ear that the numbers will change because 224 will be policy, 225 will be whatever. So those are cosmetics, we'll change that. 225, as we have it in the hard copy, we are in agreement, including the amendment suggested by Honorable Singh. Mokoena still 224? 2225?
No, I wanted to check, I think I left for a second there. What are the new headings now under this?
No new headings.
No new headings, okay.
No, we just say, we split 2224 into two instead of one.
Oh, I see. No, because I want to add a different one, but maybe I can do that at the end of it, yeah, sure.
No, there will be space for people to add after 2232. We'll afford for new ones. And that will be including as well the public broadcast, not the public broadcaster, the public protector, Dr. Koza. You must just remind us when we get there to that one. 2226, as it stands, do members feel we should add, subtract? Is it opening us up? Can we defend it? Honorable Mathanga?
I just think that there's something missing here. I think there's something missing. We've just referred to the decline and didn't qualify what we are referring to. So I've just been trying to look back as to, I think there's just something, it's either the decline on, is it corporate governance? Is it whatever? Or because we are talking about the board, so we should qualify the decline as to what are we referring to. So
That's what we were saying. I think that's what we were saying. But I was saying, if we. I beg your pardon. I'm saying if we move from the assumption that what we meant there was the decline of the SABC as an organization, because you're saying there's something missing, and I'm suggesting to you that the missing part was the decline of the SABC as a institution. So if we had read it, the committee had noted that much of the decline of the SABC as an institution was as a result of. Would that answer your question? Or would it confuse it more?
I know it's coming closer, Chair.
Because you started
Yes.
it, we'll get members to comment and then you will end it up. Okay, so you'll just listen to what members and say, okay, let's start with Prof. Kubisa, and who else wanted to speak on this matter? Loliwe and Waters, and then Mathangu, you will indicate if you agree with what members are saying. Yes,
Chairperson,
Prof.
Chairperson, I do observe the angle from which Honorable Mahlangu comes from, that there should be reference to what is it that declined. Because as it stands like that, it doesn't give us any meaning. But if we limit it to corporate governance, it won't answer what we tend to answer. Rather, let's broaden it to say the decline of the SABC as an organization. In that way, it covers even other aspects that we'll be referring to, previous and the aspects that we'll be going to as well. Thanks, Chair.
Because you will give us the go-ahead eventually. After Mathangu was Loliwe, Waters, and Mahlangu, you'll end up. Loliwe, anything on 2226?
Thanks, Chair. Chair, I wanted to respond to what Honorable Mahlangu was raising. I think we are dealing with a big tree called governance, which has branches called your legislative framework, your fiduciary duties, and whatever heading is there. So I think that big tree, which is on page 67 of our document, is responding to what is really declining. Thanks.
Chair, I think if we swapped that first sentence around, it might create more clarity. So if you said the committee had noted that much of the decline in good governance and sound financial management was the result of senior managers having tolerated it until such tolerated. Okay, I'll have to think of it. Well, here it says senior managers. You see, maybe it's not even in the right. This is not the board. This is senior managers having tolerated.
Talking about senior managers, and it doesn't belong to fiduciary
No, it
duties.
doesn't.
Hey?
Chair, when we inserted that, it was specifically about senior management as well, as distinct from the board. To 2.26, is that?
No,
what-
but I said I'll always keep you honest and focused. We've never had a mandate about the performance of senior management or otherwise. Ours has always been about the board. Let's not broaden it. And that's why we're saying if the board failed in directing senior management, I can understand it. But we can never go and say that senior management didn't do what they wanted to do, because that was not our mandate. And the question is, if we are focusing specifically on senior management, then number one, it doesn't belong under fiduciary duties, and two, does it belong in this report at all? Those are the two questions, because this one seems to focus on, so when you answer, whoever it is, please answer those two questions. Does it belong under fiduciary? If not, does it belong into our report? And I'm arguing that if it's about senior managers, then it's not our mandate. Ours is, and specifically under this heading anyway, under this heading we're talking about the failure or otherwise of the board. So does Mr. Mokoena?
No, Chair, it doesn't belong in the report at all. It doesn't help us with anything. Yeah, thanks.
Honorable Killian.
Chairperson, I just feel we have dealt with a MOI under paragraph 2.2.3. The fact is, however, that as a result of what was in the later years of the board presented to them as the new MOI, a lot of their powers were in fact eroded. As a consequence of that, they could not really exercise their duties. So I just feel we shouldn't let go of it completely. But obviously they are to be held accountable. But honestly, Chairperson, if we look at the impact of this, the fact that the managers could effectively just do what they wanted. Yes, it's fiduciary duties is the heading, but we could say the board who agreed to the MOI effectively allowed their responsibilities in terms of their fiduciary responsibilities to be eroded by managers who allowed the gradual erosion of good governance and sound financial management. Because, they are held accountable, but in the end, their hands were actually tied as well.
Now, you've been very sympathetic to the board. If they chose to have their hands tied, we can't exonerate them. We really can't, honorable members, because remember we're going to deal with the MOI. which will talk to some of these things. The fact that they participated or we've spoken to somewhere else. I'm just asking the question, honourable members, should we venture into the performance or lack thereof if we can't point to the fact that it was because of the doings or lack thereof of the board? If we can't marry the two, I'm arguing that it shouldn't be, certainly not under fiduciary duties. Doc? Anybody else? Yes, we'll come to you, Doc. Before you start, the suggestion on the table by Mokoena is that it doesn't belong there. So as you respond, you must answer whether it does or doesn't.
With me, I think it does. It's just that there is something that is missing, and I want to suggest what I think is missing. In my view, I think the rapid or frequent changes of non-executive and executive members of the board led to the decline and also resulted in senior managers, having to tolerate the gradual erosion of good governance and sound financial management. When you don't have stability at leadership level and there's that frequent change, there is you are not building that institutional, the strong institutional systems to sustain good governance. And that's my view. I think somehow, maybe the phrasing, but I think it does belong there because there was gradual erosion. If you look at it, when you had, how many CEOs, for example, you had there? How many group this you had there? How many members of the board that you had that were changed all the time? And I think it links to that. That's the point I'm trying to make. And we have an Englishman here. I mean, he can help with his English. It can come handy now. Yeah, come.
Honourable Swartz, and then Mokoena, you're going to have to take us out of this hole or bury us in this hole because you sponsored it.
I'm
Yes,
just
sir.
trying to, either we take out the paragraph at all, but there must have been a reason why we inserted it. And it's not the only reference to senior management. There are other references as well, Chair. So as it stands there, I think we should add to the board and senior management, because we need to remember, Chair, that an example of a senior manager is Mr. Shushu that came and gave evidence to us about procurement, and his evidence was very good, but there's also an obligation on him, as the minister indicated, rightly or wrongly. If you were aware of the wrongdoings, you should have reported it. There's a legal obligation in terms of the Corruption Act, in terms of the Public Disclosures Act. So while our mandate is to look at the board, we can't neglect senior management, because on the next paragraph, 22.3.1, we say we noted with concern statements by the SABC senior management and Professor Maguva. So it depends what we mean by senior management. What do we mean by senior management? Is it your managers or is it your board members? And so maybe but I do think there is space for in our investigation to look at the role of senior management briefly and allude to that. So I don't think there's a problem with this if we tie it in with the board as well, Chair.
That's fine. You're digging us out of the hole. That's fine. Mokoena, you'll wrap it all up. Suggestion is that senior managers and board, or senior managers meaning in actual fact executive managers. Then we must be specific. Because there's a difference between senior management, ExCo, the executive, the three executives that make up the board. Then we must be specific. But I'm just saying let's make sure that we are not challenged. I noted that Killian wanted to speak. Do you want to speak, sir? Those two, and then Mokoena, you'll take us out of the hole. Killian?
Yes, Chairperson. I fully concur with Honourable Swart. I believe that we should just build it in in such a way that it is eventually, because remember there were many of them who were purged, so there was a rapid turnover. So we could say something that the committee has noted that much of the decline was the result of a high or a rapid turnover of the executive managers and directors, which resulted in the gradual erosion of good governance and sound financial management. Then we could say the board did not, the board did not note this, because remember, Professor Maguve was before us, and when we asked him about the high and the rapid turnover and the fact that there were so many people purged, etc., I mean, it was really shocking. He said he was not aware of it. So it appears that the board just closed their eyes for what was happening in the senior management. So if we could bring that into, to link it to the board as in terms of their financial duties, but fiduciary duties, but also refer to it as the rapid turnover of executive managers. Remember, there are 3 chair who are directors sitting in the board, and then there are 11 others. So that's a total of 14 in the executive of the SABC. Thank you, Chair.
Honourable Waters, and then Mokoena, you'll wrap it up for us. Waters?
Well, Chair, I was going to suggest that when you look at the paragraph, we said the committee has noted that much of the decline at the SABC, so we specify where it is, although we are talking about the SABC, but nevertheless, was a result of board members and senior managers. And we've just heard from our Honourable Killian, the senior managers is the 11 executive directors, eh? Is that correct? So maybe we should then say the executive directors instead of senior managers, in order to have clarity. All right, okay. Because senior managers could mean people lower down. Having tolerated the gradual erosion of good governance and sound financial management until such time that it directly affected them. And that's quite an accurate statement, because often people turn a blind eye until, it affected them negatively. So they were complicit up to a point, not everyone, but a lot of them, and then they were on the wrong side of whoever was in charge. So I think that's how we should change the first sentence.
Mokoena, you still thinking?
No, Chair, I think Honourable Waters' input is correct. Yeah, because then the rest of it must go, and then I think the rest of it we can park and see if we can put it anywhere else later. But I think Honourable Makosi's input about the board's aloofness to the high turnover is something that we must incorporate in there. As and I'm not sure. Maybe Honourable Makosi can sponsor us with a sentence or two.
No, No, I think if members talk about executive, then I'm comfortable. Senior managers had a problem with executives. Is true. Everybody there, as we speak, are acting anyway, and there's been acting. I don't know how many CEOs have been there. So, if we change it to executive, I'm able to defend it. If you say senior managers, it's the problem. But we seem to be thinking that we're saying executive, and the fact that there were so many and there was a clear sign of instability, certainly at that highest level, was a direct result of where SABC is today. I mean, that's an observation. And the board had a responsibility of making sure that at least there's stability. If not stability, they used to make sure that there's retention. That's the accounting officer's job, to make sure that there's retention of critical staff. So, all right. So in broad principles, we agree with it. As it is, changing senior management to executive management and adding at the SABC. Yes?
Yeah, Chair. Well, SABC is mainly responsible for television, so we can expect more actors there than anywhere else.
I think the proposal is fair, but I guess we can also even add that there's even irregular appointments even at that level of your executive. Because it shouldn't just be the changes, but including irregular appointments at that level.
The decline was because of irregular appointments. Remember, we were talking about the decline. We noted that there was a decline.
Yes, they play a very major role.
The irregular appointments was part of the decline.
Of them, the executive managers.
I think. So whilst we're away, Cindy will try and wordsmith 226 for us. I think you've got the sense.
Chairperson, can we add there that vast sums of money were paid out to get some of them out of the system? The mutual separation agreements.
No, but where are we going to put that? You're saying we must put it in there? I'm sure we can. Cindy will be here. Maybe you must capture her. Eh? Honourable members, we are on 2227. A one-liner. I'm trying to understand the context in which we put it in there. And has it not been covered by suggestions made earlier on? Remember, we're talking about the board and its performance. I'm not sure if we've covered it somewhere else, or what were we trying to say or how will we defend that one if we left it in? Those are the questions that must always be at the back of our mind. Honourable Killian and then Honourable Mokoena.
Chairperson, at first glance, I did not have a problem with it. I just have one little question mark, and that is whether these operational decisions were in fact not part of the delegation of authority framework, which were no longer presented to them. That is just the sort of the caveat that I wanted to place there, to say, can we accuse them of that? Is it as a result of that, or is it because the DAF was amended, and which gave the executive free rein? That is just my concern. Thank you.
Honourable Mokoena and then Honourable Chauke.
The context that would be relevant for me in this particular case is the lack of the board to maintain the integrity of the SABC in as far as contracts like the TNA and multi-choice and so on and so forth. These are operational decisions that could have, I think, compromised the integrity of the SABC. And the board failed to oversee that.
Yeah, no, Chair, due to the removal of a power of the board, both the MOI that give power and delegated the executive to be the ones that deal with issues of operation. The board was no longer involved there. Maybe we should craft a line that deals with, but it will definitely fall under the MOI, not here, that deals with the removal of powers of the board, because they were no longer in charge of the operationals of the organization. So therefore, I'm going to propose that we try and locate under the powers of the board, removed, maybe under MOI rather than putting it in this line, because by this time, the board did not have authority anymore on operational matters.
No, I'll always play devil's advocate and whatever. I mean, when we look, honourable members, at and I'm sorry that we always harp on it, but there were some contracts where the board was still in place when they were not signed or whatever, so we can't exonerate the board that it was through DEF only. It's true that DEF played a certain role. But there were other instances where we had evidence that the board either, after legal opinion, were divided or were complicit or whatever the case might be. So I don't have a view one way or the other, but just to say that, well, it was because of the DEF or the MOI and therefore they must be exonerated. That's all that I'm asking. I mean, and that is why I'm arguing, somebody must convince me that we must take it out. Let's take Chauke and then you'll follow Killian.
Maybe, Chair, maybe the line will be to deal with the impact of the DEF and the MOI, which sort of strip the authority of the board. I'm not saying that you remove it to that extent. Maybe we then deal with the line that says the implication of a MOI, I mean, of DEF and MOI led to the board failing to do oversight over operational matters.
Chairperson, I think we can make that one work, and I would like to propose the following. We keep it as it is. The board failed to ratify operational decisions, but then we insert or to engage the shareholder on the implications of amendments to the MOI and the delegation of authority framework, which impacted directly on the public broadcaster's mandate, its financial management and competitiveness.
I'm looking at other members. Can we put that in as is? Yes? Thank you. That's 2227. 2228. Remember, we're dealing with observations, we're dealing with findings, and we're dealing with the failure of the board to exercise its mandate. Anything outside of that will have to find a home somewhere else. So does this fit here? Does this make sense? And can we defend it in terms of the board? Any takers?
Chair, just on the reference to round-robin decision-making, we might need to just add after that in brackets, albeit later ratified at the next Corate meeting, because that's what they say. And we can accept that. I think there was a question as to whether they were meetings of the board or not, but I think we need to say that we can qualify it by saying purportedly ratified, but we need to just make that there was an attempt to ratify, or whether they were ratified or not at the next meeting. So the suggestion is round-robin decision-making, brackets, albeit later ratified at the next Corate meeting, close brackets, full stop, or purportedly ratified.
All right, before we recognize Waters and Killian, can I make a suggestion? Because I think this was very early when we were very inexperienced. If we took out the first two lines and we said board members reported unusually large numbers of board meetings and so on. Because we're talking here about the board's functionality or otherwise. So my suggestion says, and we'll allow you Waters and then we'll allow you Killian, but I'm just suggesting, and I don't know who introduced it, they will defend it. My suggestion says we start with the reason why they were not functioning was because they met too often, they met at short notice, they met round robin and all those type of things. So that first part about the organizing, I don't think should be there. That's my view, but I'd recognize Waters, I'd recognized Killian, I'd recognized Mathangu, I'd recognized Kubisa, I'd recognized Chauke, and then Honorable Swartz, you will wrap it up for us, sir. Swartz, you want to say something on that matter? Okay. Waters?
Chair, thank you. Chair, I'm not sure I read in the SABC's documents or anywhere else that with round robins, all decisions were then ratified by the board at a formal constituted meeting. I don't remember reading that. What I do remember reading was an explanation in the SABC's submission where they said in one instance, and I forget the issue that was being addressed, but they did a round robin, and then that particular issue was ratified by the executive of the board, not the full board. Do you remember that? Yeah. So I don't. Yeah, we dealt with it yesterday actually, but I don't remember the SAB saying that for every round robin that happened, there was then a follow-up meeting of the board that was Corate. So I would suggest that we just leave it as it is.
But bearing in mind, honourable members, I agree with you. We don't have to take it as gospel. But I recall Teresa Geldernes talking about round robins being ratified. But I'm saying, and that goes to transcripts. But we'll take all these points and look at it. But yeah, let's take the next speaker. Mathangu, I think it was you.
Chair, my view is that we should leave the whole paragraph as it is. Remember, the board secretary is a very important person in the board. So, and he has this responsibility to guide, to advise, and so on and so on and so on. So, having all these things that we are talking about, of many meetings, short, are things that the board secretary would have advised whoever convenes the meetings that, no, I don't think it's the right thing, in terms of whatever. So I think the sentence is perfect from where I am.
Chair, oh, sorry.
Sorry, Chair. Chairperson, I also believe that we should maintain it, we should keep it. The role of the Company Secretary is a crucial one. It's described in the Companies Act, it's described in the MOI. You will recall that in the Auditor General's report, they referred to, Public Protector's report, they referred to the vast number of special, and the Auditor General, special meetings of the board, which created instability. Now that continued. That was a part of previous boards. That continued. There was a schedule of meetings presented by the Company Secretary, and we posed the question. We said, why so many special meetings? Where's your plan of regular meetings? So I would like to suggest that we maintain it, but that we don't only refer to the former board members, because it's not a gossip story, it is fact. Evidence was presented that there were an unusually large number of special meetings convened at short notice and without proper notification and adequate documentation, and frequent round-robin decision-making. The fact is, irrespective of the fact, we have engaged on that matter before. You do not have, and some of the board members complained, they said they didn't want to have any engagement on matters. They would prefer the round robin because then there would be no differences of opinion. And that is a very bad thing, Chairperson. So we should not try to cover up to say, yes, but it was ratified afterwards. That's not the point. The point is, why does a big corporation operate on the basis of round-robin decision-making? You cannot operate such a big company like that. So I would like to support the idea that we keep it in. We can maybe fine-tune it with, say, evidence was also provided, but we keep it in, please, Chair.
Honourable Professor Kubis.
Chair, I would have divided the sentence into two. Said, like saying, despite the company secretary having served in the position for a long time, for a long period of time, and having been highly experienced and highly qualified, evidence suggests that she failed to guide the board accordingly, full stop. Then the next sentence will start, former board members, or we say board members, then that would be a new sentence altogether. Or the sentence that follows. I'm saying.
No, I'm saying the sentence that follows, we take it as it is then.
As it is.
Thank you, sir. Chauke, Swarts and Waters.
Well, thanks, Chair. The Prof has covered the point. The point of yours is we need to make a reflection on the company secretary, and I think the separation of this paragraph, in fact, they begin to speak of the secretary and the role of the secretary. As much as we're dealing with the board, obviously the next person that comes in automatically is the secretary of the organization, who is the key person. So I think that Prof, in his separation, he made a very good point there. So we can separate, have a reflection on the company secretary with the very same heading as we deal with his qualification, experience and all of that, but then fail to advise and give direction to the board. And I think if we had to follow that line paragraph, it will make sense, because I wanted us to reflect on that particular office.
Thank you, sir. Swarts and then Waters.
Chair, there definitely is evidence about the decisions, firstly, round-robin decision-making is allowed in terms of the Companies Act. It's not desirable, but it's allowed. But if you look on page 133 of the report, it says there that, it says all round-robins, their approval at the next meeting. These were tabled at the next court meeting to be ratified and written. There's an annexure of all the meetings for the 2 years, and all of them were ratified. Now, we did pick up that one was purportedly ratified at an EXCO meeting. So I'm not saying that, I'm not accepting necessarily this version that all ratifications were correct, but just to say that there was decision-making without any reference to any subsequent meeting. It's a small sentence, just to put in brackets, albeit later ratified at the next court meeting, full stop. That's only the suggestion. And then the next sentence that starts this contradiction, well, it's not a contradiction. It's a modus operandi, I would suggest. That if we are then saying this modus operandi appears to point to deliberate attempts to stifle board, that would be, I don't see a contradiction, I see rather a modus operandi. So I just want for us to consider that to correctly reflect what factually happened. If we look at the annexures, there are annexures of every round-robin meeting and ratification in Annexure AC 26 of the documentation. So we can't say we don't know about that, Chair. And there was other evidence as well.
Honourable Waters?
Chair, I mean, having round robins, as we state here, does stifle divergent views and sharing of cross-pollination of views and trying to convince someone that maybe your idea is correct and theirs isn't, and winning people over. And while I hear Honourable Swartz, the fact of the matter is having a meeting after the fact where, the decision was, the round robin happened, whatever the decision was could have been implemented, and then a week or two or a month later, then you have a Core board meeting that ratifies it, does show the rot of governance at the SABC. So I think we've captured that correctly. Chair, if, the Honourable Swart does refer to page 133 where he says the SABC does say that they did have board meetings to ratify every decision. If we put that in, I don't think it detracts then from the fact that there were many, many, many round robins taking place. Yeah.
Okay, we'll marry the two, because I'm saying it doesn't dilute the fact that there were extraordinarily high occasions where round robins were how decisions were taken. So I don't think it divorces or it dilutes that. Can we, Honourable Khoza suggested that we add the paragraph that says the board failed to implement fully, I think, Honourable Khoza, because they did it partly, I think, fully implement the public protector. Sandy, have you got that one? We need to do that. That's what she suggested much earlier on, that we point to the fact that the board didn't implement it in full and also didn't take it on review, I don't think, did they? No, they didn't. So we'll add that one. I don't know. Mokoena, you were also saying that there'll be one more that you'd want to bring in.
No, Chair, I think we also need to comment on the status of the board as we speak now. And that decisions had been taken unilaterally by the GCEO, which are decisions that should be taken by the board, right? The acting GCEO. So I crafted a thing to say that the committee notes. Okay, no problem. The committee notes that at the adoption of this report, the SABC was without a board, because initially we said that it was dysfunctional. Without a core, yeah, okay? All the non-executive members were either dismissed or resigned of their own accord. There were only two executive members who are in acting capacity, with the acting GCEO currently making unilateral governance decisions, as was observed in the appeal case against the Western Cape High Court's decision to dismiss Mr. Mutweni. I think we need to put that so that because then it will inform our recommendations as well.
No holy cows and no silly suggestions. All of them will be put on the table and considered. There's an addition. Oh, the public protector, I'm assuming we're all in agreement with. There's a suggestion that says we should talk about the current status of the board or the board as it will be at the end of the day tomorrow. Happy? Yes, Honorable Killian?
Just when we adjourned to go to the House Chair, I made the comment about my concern that there was such a high staff turnover and that there were so many cases taken to the CCMA and all of that. So the human resource management was in tatters. And we did not get any indication that the board was concerned about what happened. I think one of the former board members, Ms. Kalida, said that they were not aware of the amendment to the MOE, which effectively allowed the executive to no longer bring the human resource matters to the board. Now, that resulted in huge financial losses for the SABC because so many people were, in fact, given mutual severance, mutual separation packages, mutually agreed separation packages. So I think we should capture that one as well, Chairperson.
The point I'm making, Honorable Killian, 2227 says, had a direct impact on the public broadcaster's mandate, its financial management, and its competence. That talks to your point, or do you want to be, because once we go to HR, then we must go to others, but we are saying that it had an impact, their inability to perform as a team had a direct impact on the financial management. Are you happy with that one? Or do you still want to add your one? No, thanks. All right, 2228, it'll change obviously because we added one, and we've added the two about the implementation in full or taking on review of the public protector's report and the current status of the board. Those are the two that we've added to this. Is there anything else around fiduciary duties that members want to add? No. Yes, Honorable Killian.
Chairperson, I hear what you're saying about paragraph 22.2.7. I was under the impression that we would probably get to a recommendation where we would argue that appointments made in recent times, some of them clearly irregularly. So, if we don't mention that in our observations as a matter of concern and an oversight by the board, how do we then jump to that recommendation? I just want to make that point. And that is why I thought it was important to make such a sort of a finding with regards to serious challenges in the HR management of the corporation.
Can I refer you to page 73 of your document? 2511. Thank you very much. So that deals with fiduciary duties. The next heading, financial management and sustainability. That is on page 69. Cindy, you want to say something? Oh, no. Oh, sorry. Cindy is reminding me that before we go to financial management, Dr. Koza had suggested that we have a new heading called dysfunction of the board, and I think you said we must take one because we're going to we're going to use it as a recommendation. And I think that was 22.2.1, the first sentence. Can members just go there? You've got that one? On page 67. 22.2.1, the very first sentence will then go under a separate heading named dysfunctionality of the board or something to that effect. Is that okay? Are you talking on this point? No, I'm asking Chauke, are you talking on that point? No, yes, I'm saying, when we were there, Dr. Koza suggested we take the first sentence out, put it under a separate heading. Now I'm asking the question, is that still what we want to do or not, before we even go to anything else you're saying? Then we'll come to you, Chauke.
Frankly, I honestly don't think, I would be happy even if we leave it out. The reason being that I'm thinking that we have a whole range of other points under fiduciary duties. And maybe if we put that one, it might mean that we are only focusing on that, if you know what I mean. I don't know if...
But I think, I agree, but I think that almost ties into Mokwena's, just read that sentence. Does it not tie into a certain extent, Mokwena, to your sponsored one? If you read the first sentence on page 67. On page 67, the first sentence, 22.2.1. Just the first sentence. The question is, do we take it out totally or will we marry it? What you suggested. I know it doesn't cover everything, because Dr. Koza is suggesting we take this one out totally, and I don't have a problem with that, but we'll come to Chauke if she wants to talk to that. Just look at it whilst we listen to what Honourable Chauke is saying. Honourable Chauke?
Chair, I'm just a little bit lost, other than maybe to suggest that the point that we have not put in, if we were to reflect on the status of the board when we started, there's this point of, here we deal with the 3 non-executive, and we have not reflected on the only one standing man, meaning that the non-executive, Professor Maguve. I thought that maybe we'll have, in line with this line, if you don't take it out, you leave it, but add a line that speaks of one non-executive who's the chair remaining when we started the work. I thought maybe we can just add that line in that. So if you want to leave it like that, but you must reflect on the non-executive, and the non-executive that time is the Professor Maguve, who was the chair. You remember, he only resigned when, during the hearing, he then resigned. I'm not sure if we have to put that, I'm just throwing it in, but I think it will make a lot of sense so that if you look at how was the board by the time we started the inquiry, both the non-executive and the executive.
Dr. Koza, all right. I'm coming to you. Yours, I think yours is fine. We'll leave what it stands like now, but we'll come to Koza on this one.
No, Chair. I thought that we had dealt with this exhaustively. The only thing that we were going back to was the issue of the subheading. Did I get you right?
No, then me and Cindy didn't understand. When we were here, we thought we understood you to say that first sentence that talks about the non-functionality of the board must be lifted and put it under another heading. That's what we had understood you to be saying.
Yes, that's what I had said earlier. But I am saying, if you look, I think it might mess up the numbering. And I'm thinking now, because we've already gone through all the other points, and they all tie in very nicely with fiduciary duties. So I'm actually retracting my earlier proposal, given the fact that it may disrupt the flow of the document.
That's fine. And added to that, Honourable Chauke is then saying we add 3 non-executive board members and one, 3 executive board members and 1 non-executive. Just that first page, that's what you suggested. You got that, Cindy? Remember you took out? We'll find it. 2221. Yeah. We are taking it out. We're going to put it somewhere else. We're suggesting we leave it as it is. And we just add in 1 non-executive member. All right. That then deals, honorable members, with 22.2. Is that it? Yes. 22.3, financial management and sustainability. 2231. Comments, Honorable Killian.
Chairperson, I would like to suggest that we accept it. Just one little comment, and that is if we speak of the SABC, maybe we should refer to the executive management.
We can leave it in? We will come in after that, Chauke.
Oh, is Chauke?
No, you and then Chauke.
Yes, I was actually saying, I don't know, the issue that Chauke is raising, I don't, yeah, just a little bit, yes. The matter that Chauke is raising raises other problems. I think colleagues are aware that in the documents that we received from CIPC, the company secretary was also a board member. Yes, a director, sorry. But when you are a director, you are in the board. What is it saying? There's just something that doesn't gel properly, and something that we've not obviously dealt with, but something that we must clarify because it's a bit of an abnormality of some kind. Not that it is not allowed, but the question of the status, therefore, in the board, because there are 2 contradictions in that board, which I think we'll deal with it later. Because remember, okay, while I'm on the floor, that in 2012, Tlawudi was a director, 2011, sorry, a director, and we know that he served on the board as a, I don't know, now I would assume, having read this 2011 thing, that he actually was an additional person over and above the 3 prescribed EXCO members. So it's a huge anomaly. But yeah,
I'll keep on keeping you on the straight and narrow. We're talking about the fiduciary duties of the board members. Now, if having an extra one or one that was put on illegally or put on differently affects the fiduciary duties, let's entertain it. But if it's a standalone, let's have it as a standalone. Because remember the heading we're dealing with now is in line with our mandate. Was this board in its... So I'm just wanting to caution against that. But when you answer Mokoena and Waters and Chauke, try and respond to Honorable Mahlangu's point, and then Mahlangu will have the last bite. Mokoena?
No, Chair, I think in terms of fiduciary duties, Am I protected? Sure. I think in terms of fiduciary duties, we're covered, right? The issues that Honorable Mahlangu is raising and Honorable Chauke are important in terms of the administration, the shareholders' administration of SABC matters, because those issues of CIPC, I think they will then fall under, we should have a new heading under the role of shareholders' representative. We should have a new heading that deals primarily with the documentation of the SABC, and that would deal with the MOI being registered, the directors. It will deal with those issues of Hlaudi being a member from 2011 when he was not a board member. Then we can clump all of that under that heading. And maybe we can call it shareholders administration or something, I don't know.
Chair, in addition to Mr. Motsaneng being a member of the board via the appointment of him being a director and registered as a director, so was the company secretary. So there were two people that were entitled to serve on the board that shouldn't have been there. I think the company secretary date was 2012 in that document, in January or something. Eh? So it's a classic case of loading a board in order to get a certain outcome. Because you have two people with votes, I take it. I'm sure we'll have to get the minutes or whoever does the investigation, where they could have actually swung decisions of the board that wouldn't have otherwise been swung, if I can put it that way, or voted for. Do you get what I'm saying? They deliberately loaded that board. No. That's how I see it by... Oh, what? No, okay. No, I'm not. Don't worry. I'm used to... it's great. In Parliament, you get heckled. It's better. At least you know people are listening. So that's a concern I would think we have to raise and stipulate in our observations as well, if the other members agree, obviously. And I do agree it should be a separate heading. It's extremely serious matter that, I mean, because the Broadcasting Act is quite clear who can appoint and how people get appointed to the board. And you can't just unilaterally just make, you know, I like Patrick, so say he's a director now and I submit the form. So I think we need to stipulate that because the rot goes very far and deep and we need to emphasize that.
Yeah, no. Okay, sorry. No, maybe, Chair, the point that Honorable Mukwena, in support of Honorable Mahlangu, and earlier when I started, very, very early, Chair, when we were still dealing with the legislative requirement earlier, there's a point that I made at some point, and that point was sequence of flouting of the law. Maybe we then locate this point. And, and I even make an example, Chair, to say your MOI, all of that, maybe if they're listed together. Because there's this other point that I wanted to bring, Chair, and you're going to forgive me, Chair. And we have not reflected on it either through our observation. There's this thing that Gelden's company secretary, together with Mr. Muthambi, are directors of a particular company under SABC. It was raised during the, and we have not got into that detail. And I want to propose that maybe as we deal with some of these directors' position and what, have somehow a reflection on that arrangement of a private company owned by Muthambi and Gelden's, because it may be operating even outside SABC. So I'm saying that maybe we have to package them under governance, maybe, under governance, legislation, policy, yeah, I want to propose that maybe we locate this. We may come back to it. I don't have a wording for it now, but I think the sequence will be, it must follow under, issues relating to legislation and which deals with requirement, MOI agreements and all of that.
Yeah, Chairperson, no, I agree that this matter needs to be located somewhere, the one raised by the two honorable members here, not necessarily here. See, because we heard evidence as well at some stage, I remember whether it was Dr. Ngubane, where there were specific questions about the presence of Mr. Motsoeneng at board meetings. And then we were told, well, then we were given, told about his efficiency, et cetera, as a young man and what he did in the trenches and so on and so forth. So I think the issue about his attendance at board meetings did come up in evidence. Now we've realized that he was a director, right, as far as CIPC documents is concerned. So what we have to further examine, I don't know if it's us or whoever, or make a point about, is did the company secretary and Mr. Motsoeneng attend in the ex officio capacity? Because you do get people attending board meetings ex officio. Or did they attend as directors? Correct. Because I would think that they attended because they were directors. But there was a debate on whether or not they should actually be there or not. So it's an important matter that we need to observe and make a finding on so that it can be clarified moving forward. Thank you.
No, Chair, I think, look, there's a difference between a director and a board member. A director is one who is registered in the CIPC documents as the accounting authority or the owner or shareholder, so to speak, of a company. And then the board is somewhat similar, but in the case of the Broadcasting Act, it's someone who is elected by Parliament or whatever the Broadcasting Act says, plus the 3 executives. So the roles there were muffled in that you had Hlaudi who was sitting in board meetings, not as a board member, but probably as a director. And that's and those are the chaos and the contradictions that the minister should have taken care of. I think it confused the roles of who's who in the SABC, and that is the shareholder's responsibility. And that's the reason why I think we should have a heading in the on page 70 under the role of the shareholder representative, to say that she did not oversee any of this chaos in terms of the documentation, who's who, and all of that. So I would place it somewhere else, not under fiduciary duties.
Chair, I'm not sure if this is going to fall under fiduciary duties or where, but I think that we need to be pointing something that says evidence from CIPC on the status of directors at SABC reflects Motsoeneng as a director and we put the date from the 28th of November 2011, and Gelden Hayes as the director from that specific date. In other words, we become specific. We refer to that document that we have. And this suggests, to the committee's view, this may suggest a serious breach of the provisions of the Broadcasting Act. Something to that effect, but we may have to get the relevant section of the Broadcasting Act.
Chair, I think it's well said. I think we can live with what the last speaker have said.
Okay, so the point that you've made is we'll find a home for it somewhere else. I just wanted to come to Mukwena's point. There's no distinction here. We're calling it a board, but its full name is Board of Directors. So there's nothing that is a board and a director. It's a board of directors, 12 of them or 9 of them through us, 3 by virtue of their position in the office. That's how I understand it. But what I was trying to say that it's the same thing. That's what I was saying, but let's listen to Mukwena. That's how I understood it. There's no difference. I'm talking about SABC specifically.
The point I was making, Chair, is that yes, there is no difference, but in the manner in which it was dealt with at the SABC, there was a difference because you have a person who is not, by Broadcasting Act principles, should not be a board of director, but they are, and they are registered as such. So, yeah, I'm not sure if I'm clearer.
No, I'm saying there shouldn't be confusion as if there's 2 categories of people that should be the accounting authority. That's why it's better to call it accounting authority. Yeah. Are we still on that point? We've now agreed that we're going to find a home for it somewhere else and not under fiduciary duties. So can we move on to financial management?
Okay.
Can we? Thank you very much. We were on 2231. No, that one we had dealt with. Yes. Yeah, 2231, Honorable. Anybody want to talk to it? Yes, Dr. Koza.
Chair, I thought that we may have to, probably before regardless, under 22.3.1, I thought that it might be important for the committee to pronounce itself that, probably let's have a sentence that this reflects. That means we are talking about their view of the fact that they are not accountable to Parliament reflects their ignorance on, on what constitutes a public, on the ownership of the public institution and yes, on the charter of the corporation, because to me, that's what it reflects. If we are saying you can't account to Parliament, we've got to say something to that effect, that before we can go to regardless. You understand what I'm saying?
Okay, except to say we won't use the word ignorance, we'll use the word lack of understanding. Is that one fine?
Well,
Yeah, I'm just... No, I agree. I'm just... Lack of understanding, eh? Yeah. 2232. 2232. Any comments?
Just the 2 that must get in, Chair, after that it had failed to put in place.
Okay, you got that, Tony? Okay, that one is okay? That's factual. 2233. We recognize Waters and Killian. Hold on. We're going back. Let's just go back.
Sorry.
Yes, sir?
That second sentence in 2232 is actually the finding of the Auditor General. We state in it as a fact that it's our, should we not say there, it found that the SABC board? Because we state in that as a sentence, but if my memory is correct, that was a direct finding of the Auditor General. So it does make a difference. Either we are stating it as our finding, or it's the Auditor General. But it was definitely the Auditor General's finding in the second sentence. It's quite, it's important.
But if we associate ourselves with the Auditor General's finding, can't we do that? Or do you want us to qualify it?
All I want to say is full stop, it found that the SABC board had failed to discharge its duties. And then that's the quote it's from their financial statements. But if it's our finding, then it's different. Or we support the finding that the SABC, but that word in there is it us or is it the Auditor General?
All right, any comments on that one? Yes,
No, Chair,
Swarts is still on the floor.
No, Chair, that's it. I just wanted clarity if it was our finding or the Auditor General, because there's a big difference. We can associate it with the Auditor General, or it can be our finding.
Our findings, because we never did any investigation on that matter. It was the AG's findings.
Then we should just say it found that the SABC board has.
Mr. Mokoena? And Singh.
Yeah, no. I would leave the first sentence as is, because that is factually correct, right? And then say, in lieu of this fact, the committee then found that the SABC board had failed to discharge its duties, because that is our finding.
Yeah, that is fine.
Yeah.
Yeah, Chair, I think that's going back, that suggestion is going back to what Honorable Swati is telling us we should not do. Yeah, that's what I'm saying. You know, so I don't know, I'm going to say we note, that's us, from the AG's report, that the SABC had failed, whatever. We note from the AG's report that it's an observation.
Chairperson, surely the committee, after it has been exposed to information that this was the finding of the Auditor General, we must find that they did not discharge their duties and that they failed to put in place measures to prevent irregular. I mean, we were not the auditors, but clearly we all know what the Public Finance Management Act says, that accounting authorities must put in place effective measures. So it is our finding that how could they have been found to have wasteful expenditure and fruitless expenditure to the value of 92.8 million rand in one financial year if they had in place effective measures. So I would argue with that. It's not only the Auditor General, it's this committee that finds this well.
Swarts, you'll have the last say.
Well, maybe my point, Chair, is covered with the SABC board. I was going to try and go deeper to the accounting authority. If we were to look at the PFMA, it speaks directly to the, well, obviously here the accounting authority will be the board, but I do not want the board of the, meaning that the CEO and everybody, they are members of the board, non-executive. So I'm fine, but because I was going to insist on the accounting authority rather than using the board, but it's fine if the board covers the rest of the people on accounting. Because issues of fruitless, wasteful expenditure, you'll know, Chair, that at the level of the executive, measures and systems are put in place from that level of the accounting officer will be your CEO, but here I think we're now dealing with the board. I'll just leave it from that point. But I was going to try and insist on the accounting officer, but it's fine. The board is correct. Am I out of order? This was up.
Chair, I want to align myself with Honorable Swart and Singh. You see, if we're now going to be putting it away, Killen and Honorable Mokoena are putting it, that would be tantamount to plagiarism. We never conducted any audited SABC. But what we found through oral evidence was that indeed the Auditor General, we concur with the Auditor General and we support the Auditor General. But we did not find that there is fruitless and wasteful expenditure. We didn't do that. And I concur with Steve and Honorable Singh. I think let's stick to that, man. I don't think they would be really offended if they just give way to that, because now we are the majority, you see, and now you are the minority now, the two of you.
It's easy, Chair. We just start the sentence by saying, the Auditor General found that, and it goes on the sentence, had failed, because that comes directly from their finding. Then we could, if we want to say further, the committee concurs with this finding. We could add that as well. Or agrees with this finding. But it's important to say that this was a finding of the Auditor General. And it's definitely, that's the wording they use. So it's easy to start the sentence by saying, with the previous sentence, the Auditor General reported, and you say, it found that the SABC board, etc., and then you've got to put in, after failed, you've got to put in TO, to put in place. Not failed, put in place. Failed to put in place effective measures. Full stop. The committee agrees with this finding.
You'll force me to vote. You guys are going to force me to call a vote against Killian and Mokoena because they seem to want to talk. You'll still have the last say afterwards. Mokoena, everybody seems to say, let's say we support the AG. You have a different view.
Chair, we conducted interview after interview with the minister, with the boards, with everybody to ask them what was their responsibility. I remember when we asked Maguve and we said, why did you not conduct investigations into the fruitless expenditure that the AG had found? Those were our questions. We were inquiring. We then found them wanting. And so it is correct to say that the AG report, otherwise we're rendering this committee a lame duck, and we must be careful of that. It is correct to say that the Auditor General reported fruitless and wasteful expenditure cumulative to whatever. That is a factual statement. But it is also correct, and I disagree with the fact that we were just plagiarizing the Auditor General's view. We conducted an inquiry into the AG's report with board members and everybody else, and our finding was that they had failed. We must own that responsibility. It's not the AG who told us and then we just kept quiet. We inquired and we found.
Can we put, no, Matot, I say Lalabash. No, we are playing. Can we say after having received or listened to or whatever, the evidence, the SABC board failed? Because that came after our hearing, whether it's with the AG, whether it's with whoever. It was not something, and I think both points are there. We didn't go, it's not our original idea. We heard it from somebody, like we heard from the public protector, like we heard from ICASA. What is the difficulty if we said, after having heard all this evidence, we now support the view? Can we do that? I'm going to have the casting vote. You're going to be the absolute last one, ma'am. If you can't convince me, that's where we're going.
Chairperson, I will agree with what you're suggesting. We must remember we're now coming to our findings. We have listed pages upon pages. We have a whole section on the Auditor General. The Auditor General has convinced us. So this is now our section of findings. We're not plagiarizing anything. We're just coming to a conclusion, Chairperson, from which there will be recommendations that we will draft. So please, let us just remember, these are our findings. Otherwise, why is it here?
We're all agreeing on that one. Cindy and I will break the impasse and you'll get a document tomorrow and you'll agree with the wording or disagree with the wording. So can we move to 2233? 2233 is one of those that were cut and paste from the one-pager. Killian Waters.
Chairperson, I just want to suggest that we use the Auditor General's findings instead of Auditor General's report.
Honourable Waters? Yes, sir.
Chair, I have a different view. I don't think it should be in findings. This is the SABC's own personal view about the AG's report, which they dispute. And should it not be under Section D, the summary of inputs, and on page, if you look at 52 of the report, SABC finances, we can stick it in there if you like, but they're disputing the AG's report. It's not a fact. And I don't think it's our finding at all.
No, it was originally there. Yesterday, you guys said take it out of there because it's your statement. We brought it this side. Now you're asking us to take it back. Because I hear what you're saying, Waters, but we are saying we've heard the AG, we've considered what the SABC is saying, and in our view, these two things are contradictory. And when we said that in the inputs yesterday, members said, no, but that's not an input, that's your view. And that's why we took it out and put it here. So you must tell us where unless we change the wording, but you must we brought it here as a direct result of you as members saying it's not, we can't locate it within the SABC, it's our view after having listened to both of them. That's what we said yesterday anyway, and members will concur. So are we happy? No. Waters is saying it can't stay here. What are you saying, Swartz?
Well, it goes to the essence of the process that we are engaging on. And that is the law advisor said there must be a weighing of versions, and then you reach a finding. So here we are weighing versions. We've got a version from the SABC, we've got a version from the SABC, and we say we concur with the version of the SABC. So maybe one can tweak it around but to substantiate the finding we are reaching. But it does again illustrate that we are, that's why it's there, that we are considering what the SABC has put. And we are weighing it up with the AG's report and saying, no, we concur with this is what we found. So it's very important that it is put somewhere. I think that it can be there. It's because the finding, you've got two versions. You've got the AG says this, fruitless, wasteful expenditure. Then you've got the SABC says this, and then so we accept what the AG says. You see, so that's a finding. So that's one way of looking at it. I'm not saying it necessarily has to be that way, but it's possible.
Waters, now you'll be the last. You've introduced it. Let's hear what everybody else says, and we'll come back to you. Loliwe, Killian, Mokwena, Koza, and then Waters, you will take us out of the hole that you dug for us. No, it's fine. Loliwe?
Chair, I think in that paragraph we have what the committee is saying as well as what SABC is saying. Because the first part talks to what we as a committee are saying. I suggest then that the part which talks to the view of the committee should remain where that paragraph is. And we take the latter part, which is the last sentence there, where the SABC, but we take out the however part. We say the SABC contends that its fruitless and wasteful expenditure was caused by the impairment of foreign wara. We take that to page 52.
Right.
Because they would have said that in page 52, but in our finding, we noted that the response and all that what is captured there.
All right. Killian, Mokwena, Koza, and then Waters, you'll have the last say. So you'll hear what everybody else is saying and take that.
Chairperson, I would agree with what Honourable Loliwe is saying, but I just wanted to say we must be very careful. The SABC is being audited through a very thorough process by the Auditor General. We have seen the very last, the final management letter with all the details, etc., etc. Now, we cannot allow any uncertainty as to where we will give our support. And therefore, it is, we should phrase it then in such a way that we say the committee notes the response to the interim report, where the SABC contradicts the Auditor General. However, because in the previous paragraph, we have supported the idea, the Auditor General. So we must make it very clear that we support the Auditor General, notwithstanding the fact that the SABC has contradicted that, and that we then indeed move the second part of that section to where the SABC's responses to financial management and auditing is. Thank you, Chair.
No, Chair, I was going to say our role as an inquisitorial committee or inquiry is one of the things that characterizes us is, or characterizes the work that we do, is our weighing up of credibility of our witnesses. In this case, we have the Auditor General versus the SABC. The Auditor General has the authority to audit the SABC. He gives us a finding on his authority. The SABC contradicts it, and we want to put the SABC's view in our finding. It can't be. We're not merely this is our attitude to what the evidence we're given is. The SABC's, we're inquiring on the SABC here, and we know for a fact that there was fruitless expenditure and all of these things that the AG spoke about. We can't then refer to their view, which contradicts an authorized personality, to audit them, to contradict him, and we put it in our report. It can't be.
Hey, Chair, you know, I think the two speakers are developing a very bad habit of confusing me. Honorable Killian and Mokwena, I'm not sure they are confusing me. Because how else can the committee be noting? Because the only word that I would have wanted in this sentence was the notes with serious concern or whatever, but we must put a word that says, you know, that we must factor in how strongly we are noting this thing, because it's really concerning. And I do think that whilst I agree with them that we shouldn't be putting the SABC view, but then what contradiction are we talking about if we are not putting forward that negation, that other statement of the SABC? Because here we have a situation where the SABC is attributing all its fruitless and wasteful expenditure to the impairment of foreign and sports content, which was acquired in a batch. And the Auditor General is very specific. He's saying 57% of fruitless and wasteful expenditure was acquired due to recruitment processes not being followed. So I am saying, don't nod because I'm disagreeing with you. I am saying we cannot put this point without factoring what the SABC is saying, because the contradiction is that they are saying something else and the AG is saying something else. And Tina, we are with the, obviously we are of the strong view, not even of the strong view. We believe in the Auditor General as the supreme audit institution. Maybe we could put maybe Auditor General as the supreme, maybe let's factor in the thing that, the committee notes with concern, the SABC, contradicting the Auditor General, which is the supreme audit institution, or something to that effect. But we do need to present the board views so that whoever is reading the report can understand where is our point of contention coming from.
Chairperson, my submission is that there is no way we can have this paragraph without the side of the SAPC. And of course, to me, the sentence does not need noting with concern. At least that is my bit of disagreement with Honorable Dr. Koza. The essence of the matter is that we do note it. And we understand the superiority and the integrity of the Auditor General. So, the very fact that we're noting it and we're putting in the SAPC's side, it means that we're able to weigh the probabilities. And it then puts us in a good stead because we're trying by all means to be as objective as ever. So we need both angles, our own submission and also the submission of the SAPC.
Chair, I think we're repeating ourselves unintentionally here.
No, that's a house finish.
No, it's the end of the sitting.
No, it's end of sitting.
Don't worry.
Chair, we're in danger of replicating the process that we went through yesterday, which is to reflect everything that has been said in one batch. We've done the inquiry. We've asked questions. This is our attitude. This is our finding, our observation, based on what we found, of what we've been told. This is what we think. It's incorrect for us to then put everybody's views here. Because if we're going to do that, then we must do that with the public protector's report as well. And say that the public protector said that Mutshweneng is not fit to hold office. But we note the SABC's attitude that they think differently. We can't do that. What is our attitude? And that is what needs to be reflected in these findings. Not when we've gone past that stage of weighing up evidence, we now need to be specific and not render this committee a lame duck that just reflects everybody's views. Thanks, Chair.
Honorable Waters, when you respond, I thought, excuse me, I thought Loliwe helped us because she sort of split them, but let's hear what you're saying, sir.
Chair, what's just been said is quite correct. We haven't gone through the report, well, the observations at the moment, and said, okay, in 22.2 we said this, we say this, but the person involved says that, and put a different view throughout the observations. In 22.3.2, we state we support the Auditor General's findings, right? We support him in that regard, that there was fruitless and wasteful expenditure to 92.8 million. Now, he goes and, well, his office, not him, goes and does an audit of the SABC, asks for documents, and comes up with that finding because the documents that the SABC claimed to have weren't forwarded to the Auditor General, weren't given to him.
Exactly.
So how do we then trust what the SABC is saying to us? Simply because they say it doesn't mean it's true. They say they dispute or they contradict the AG's report in that 57% of fruitless and wasteful expenditure was not due to recruitment processes not having been followed. But if that's the case, why didn't they give him the documentation to back up what they're stating here? And that is because it's their opinion. That's all. So that's why it should be in the summary of submissions. Right? So we put it there to show that we did look at the full submission and we gave it due consideration, but that's where it goes. But we've made a decision as a committee that we are backing the AG's report, that there was 98 million rands worth of fruitless and wasteful expenditure. 92, sorry. No, 92.8, yeah. And as you said before, we've got to put our colours to the mast. It's either black or white. We can't have it both ways. So we must decide what we want to do. We either back the AG or we back the SABC in this regard.
Yeah, Chair, I try to be, to be a unifier. You know, the suggestion that Loliwe made earlier on, let's just live with that one. Which takes out that latter sentence. You know, the SABC, however, contains, she said we must remove that sentence and put it under observations, under the inputs or whatever. You understand what I'm saying? So that you guys are happy. See, we are compromising people.
That's fine.
We're saying it must be removed. We compromise.
Okay, before you, let me explain what maybe Loliwe should explain it, but hold on, because you two are the guys that are having a different view, or the three of you there. Let Loliwe repeat, Killian, we're trying to convince Killian, Waters and Mukwena. Let Loliwe give her point, I'll give my point, and then the three of you will decide if you're together with us. Loliwe, repeat your point.
Thanks, Chair. Chair, I want to request all of us to go to page 69 of the report. There's a bottom paragraph there. Starting with the word "the" on page 69 until we have the sports content, we leave that where it is. Then the part which says the SABC, however, contents, we take out content in that, but we take that part to page 52, as Honorable Waters has indicated that SABC was alluding to issues of finance. Thanks, Chair.
Right, the three of you are listening to that. My 2 cents were that I'm easy on this one, Mukwena, Waters, and Killian. You know, I don't know why 2233 is there anyway, because look, on top we're talking about fruitless and wasteful expenditure. Now, why do you choose only on that one to dig a little deeper that this fruitless is 23? If we took it out, it wouldn't weaken our case, is my argument. If we took it out totally, because already on top we've said the AG's report indicates 92.8% fruitless and wasteful. I'm arguing that, honourable members, because fruitful and wasteful, whether it's impairment, whether it is whatever, it's treated the same. So why are we arguing about whether it should be this? Must keep Lentole and deal with it. But let's hear what Singh is saying.
Yeah, but Chair, if I go back to page 53, that second sentence that we're looking at now is already there in 16.9.4. Page 53. Yeah, 1694. We state how the SABC feels. So it's there. Leave it there as how they felt, and we take it out later.
All right. I'm going on now, Bob. No, the proposal now is we're taking it out totally. You got a different view? Okay, sharp.
No, the only thing that I must cry about is that we must not render this committee a lame duck. That is all. Thanks.
That's your job as members to do that. Okay, so after After 15 minutes or 20 minutes of haggling about one point, we decided to take it out, but that's fine. 2334, we're taking it out totally. 2334. I beg your pardon, I'm sorry. 2234, yes ma'am.
On a lighter note, can we allow Honorable Koza and Honorable Mukwana to go out? They need fresh air because they are disturbing us with their noise.
2234 on page 70. Yeah, of course it'll change. I'm saying in this report. We're noting Killian for now, and members will take a stab of it as they go. But Killian, let's hear what you're saying.
Chairperson, first of all, I believe it's important that there is such a paragraph. Secondly, we have been very, very correct in how we describe things. And this one appears to be a little alarmist. And it's good that we make the point, but we don't need to go to the extent of, for instance, the second sentence. I don't agree with that. We can't just make that statement as a looming financial crisis. And then secondly, the last sentence as well, the corporation may be at risk of becoming technically insolvent. I think we must make the point about our concern with regards to the financial sustainability without sounding alarmist. My recommendation is firstly, the committee notes with concern the evidence about the SABC's poor or deteriorating financial management and sustainability. Then we delete the next sentence, and then we delete the words in addition, and we start the sentence with, there is a reference in the Auditor General Management Letter that point to uncertainty on the going concern assumptions. In this regard, the funding model is of a concern, particularly in light of the SABC's mandate as a public entity, as a public broadcaster with a commercial enterprise component. So that would be my recommendation. The funding model, Chairperson, I just want to make the point that it is only in recent years that the SABC has found itself into a funding model crisis. And there are a number of reasons for it, chief amongst those, poor financial management, because they have made profits. 6-7 years ago, they've made huge profits. So it cannot just be assumed that it is a funding model crisis, but that we can have it investigated by all means. But I just wanted to make sure that we don't just make that sort of final determination that it is a funding model crisis. Thank you, Chair.
Yeah, Chairperson, this was Honourable Swart's point. And I think we agreed with the principle that we have to refer to the fact that there is a threat of it being a going concern. I don't know if I agree with the proposed amendments, but maybe we should defer to Honourable Swart to see if he can live with what is being proposed, because this was his idea that we include this, and we all agreed.
Chair, the point is, we're not alarmist. There is a looming financial crisis, and that was the whole point in the financial management document. The Auditor General's report went up to 31st of March last year. Subsequent to that, they issued concerns about whether, and that is, they prepared their financial statements on a going concern basis up to 31 March. Then they said in the management letter, subsequent to this, this is what has happened. And that was up to October last year. We are now February. And I'm not saying there is a financial crisis, I'm saying there appears to be. So I don't think it's alarmist. I think, in fact, there is a looming financial crisis, and that needs to be investigated. Part of our mandate was to look into, I'm sorry, Chair, are you able to follow what I'm saying or not? Because part of our mandate was to look into the financial sustainability. So it's not alarmist. I think that, in fact, there is a crisis. There's a crisis. Yes, it might not be, but their response is interesting. I'm just trying to find it, where they don't deny that there's a financial crisis. They are saying we've got enough assets, so we're not technically insolvent. We've got enough assets in that. But the cash flow, they say, is due to our funding model. So I think there are concerns about that. So we've put it quite obliquely, in fact, where we said there appears to be, and we can substantiate that if we want, in the financial management letter. We, in fact, refer to that elsewhere in our document where we go through. There's a paragraph in our findings in the interim document that sets out the subsequent financial status. So I think we need to be quite firm on this. And again, in this case, I think that we need to be firm. There's no harm in saying there appears to be a looming financial crisis. The corporation may be at risk of becoming technically insolvent. That is, and we could then say this aspect in the recommendations, we're going to say this must be further investigated. We're looking at the evidence that we've been given now. The SABC has not given us up-to-date financial statements that at this point in time they are able to cover everything. They've given some allusions in the report, yes, but the decrease in available cash has been quite substantial over the years of available cash in hand. They say they're able to cover their debts at this stage, but the decrease mentioned in that financial management audit report is alarming. It is alarming.
No, Kubis.
Yeah,
You'll
Chairperson.
respond, Killian.
Yeah, Chairperson, we have conducted an inquiry and we came up with a body of evidence. And this then would be given to Parliament. And with the body of evidence, somebody out there must come up with corrective measures. Hence, I also don't believe that we are so alarmous or outrageous when we say there appears to be a looming financial crisis. Because it somehow rings alarm bells to say somebody must act. And I would keep the sentence as it is. Because you are not saying that there is a financial crisis, you say there appears to be. And somebody must be on his or her toes to act on it. So I'll have the sentence kept there.
Honorable Killian, you raised, oh sorry, before Killian, Waters and then, no, it'll be Waters, it'll be Swartz, it'll be Khoza, and then Killian, because you raised that, you will take us out of the hole. Waters, Swartz, and then Khoza.
Chair, I'd like to support that we keep the paragraph as is. The financial situation at the SABC is dire, and I don't think we should water down the urgency that the finances of the SABC, as far as attention, we shouldn't water down the importance that's needed to give the attention to the SAB's finances. And if this committee, if the powers that be see this paragraph, and it makes them sit upright and do something about the funding model, then we've achieved what we set out to achieve. So I think we need to keep it in. As Honourable Swartz has said, those management letters indicate that, they clearly indicate that there is a looming financial crisis. And I think we've got to state what are in those financial management letters and, say it as it is. And so I would like to urge Honourable Killian to support this paragraph as is, so we can actually get the finances of the SABC sorted out once and for all. Thanks.
No, Chair. I've now found in our paragraph 6.6 on page 27 of the report, there we set out, and the Auditor General asked us to just change it slightly, which we've now changed, and there we set out the situation, the cash reserves and the decrease, and it is significant. If you see there if you read what we've set out in our report, there's been a significant decrease. Look, it says there's a decrease of 37% in cash in just 4 months. That is not a looming crisis, that is a crisis. And then, Chair, if you look at the SABC's response to that report, they then say that they are not insolvent, they're not technically insolvent, they've got enough cash reserves, and they deal with the Auditor General's financial statements on a going concern assumption, and that's fine. But then at the end, on page 86 at the bottom, they then admit that there's a massive decline in the cash reserves. They say the decline in cash reserves is due mainly to capital expenditure investments. This is also evident of the statement of cash flows. Capital expenditure has been funded through operational budget. Now that shouldn't be done, but anyway. And then lastly, there has been a significant increase in unfunded events of national interest that were not budgeted for. These pose a strain on the broadcaster's purse. They're not denying it. They are saying they are under financial strain. So, Chair, I think we need to leave it as it is, and hopefully someone will come alongside and assist the SABC with the financial cash crisis that they're in. Thank you, Chair.
Dr. Koza?
Chair, I'm not necessarily or violently opposed to what the members are proposing. However, I need to be clear in my mind that we understand what constitutes a financial crisis within the context of SABC. Does the decrease in reserves really amount to a looming financial crisis? And do we have sufficient evidence as this committee to make such a definite statement? Have we interrogated all the books of SABC? Because we are merely extracting something. There is nothing wrong with us raising a concern around the issues of the funding models and the issues of the funding model. I can understand if we are saying so. But to suggest that there is a looming financial crisis, members, we must understand, you see this term financial crisis, you see when you are talking about 2008 financial crisis, you are talking about banks and the collapse of everything. I mean, let's just understand, that terminology to me is not, I understand the concern, but I'm not sure if I have sufficient evidence before me to escalate it to the financial crisis at this stage.
Maybe in line with the last speaker, Chair, our focus and the guide around the financial status currently will be informed by the report of the Auditor General. And I thought that if we have confined ourselves in the findings of the AG rather than bringing in issues of a financial crisis which we have not gone deep ourselves to audit the financials of the SABC. Maybe if we can only confine ourselves in that regard, Chair, it will help us to be able to move forward easily without really having to debate things that we're not supposed to be debating around those issues. Thanks, Chair.
No, Chair, I think, Chair, again, we must not try and water down our attitude to what is happening there at the SABC. It's I think it's a fact that we're not in crisis mode as yet. but the manner in which finances have been handled at the SABC. And Honorable Swartz just, I think, yeah, he reminded us of that thing, of that 37% decrease in cash flow in 4 months. If things continue as they are, there will be a financial crisis. And that is the reason why the sentence says it appears there will be a looming. Looming means in the future. It's not happening now. And we must guard the SABC against such a looming crisis. We're not saying there's a crisis. We're not being alarmist. We're saying there could be if things continue the way they are. And that is factually correct. If the SABC does not manage its finances properly, if they do not manage their human resources properly, there will be a crisis there. In fact, now I can confidently say, it's just that I would then have to be asked the numbers, which I don't have. I can confidently say that there is a crisis at the SABC. This is the reason why we're here. The Auditor General was here telling us about the last 3 years' reports. There is a crisis there, and we must not run away from that. Our SOEs are dying because we keep this, what is that, kid's glove. We handle them with kid's gloves. And we must not. We must tell them that there's a crisis there so that somebody will then go into the SABC has been in this crisis mode for the last 15, 20 years. Then we must deal with it. And I think it's incorrect to say then it's no longer a crisis. It remains a crisis. Yeah. Yeah. Honorable Makosi must not. Sure, thanks.
She started it, but I'm not going to take another new set of hands. You'll be the only exception, Chauke, because you have spoken on it, so you'll have a second bite, Loliwe, and then we're coming to you, ma'am. Chauke?
No, I've made my point earlier, Chair. I've made my point earlier on the focus that we must focus our energy on, rather than, the point that Honorable Mkwena is making, it's informed by the report of the Auditor General. There's no other person other than the Auditor General who has audited SABC. So I'm saying that our focus is going to be what are the findings of the AG? Then we can raise the concern out of the report of the AG, which is not contested, by the way. No one has power. It's Chapter 9. Once the report is out, it's out. So I thought that we'll focus our energy there and raise our concerns, obviously. As we move to the recommendations, we can then even put the recommendations rather than wanting to debate the looming crisis, there's a bomb coming and all of that. So we can make a recommendation of what must happen. But PFMA already guides you what must happen. If the issue is about the issue of fruitless or wasteful expenditure, PFMA tells you what you must do around those issues. Maybe ours is to emphasize, what PFMA says must happen, and it must happen.
Chair, I think as a compromise position, if we say there appears to be a looming financial crisis, is fine. But to go further, to talk to insolvency, I think we are going a bit far. Can't we take the first phrase and leave the last one of insolvency?
Yeah, you see, Chairperson, actually, I just wanted to make sure that the colleagues agree with the poor or deteriorating financial management and sustainability. And then, instead of speaking about a looming crisis, I wanted to suggest that we say there appears to be serious financial challenges. If we say that, then it's not the crisis element, but we know it's been coming for some time, and then we retain the rest and we insert reference to the Auditor General management letters. And then the only other change, we can keep the one, and that's where I differ from Honourable Loliwe. I thought, if we say a corporation may be at risk of becoming technically insolvent, I think we could say that because it's a question of technicality. But the point is, I want to suggest that we're saying, particularly in light of the SABC's mandate as a public broadcaster, and we delete the rest of that sentence. Chairperson, because that, if we speak about the funding model, the public service component of the SABC's responsibility, that is what should be funded adequately. But you see, Chairperson, they are also at fault. They never report in terms of the Act on their public and their commercial entities separately. And that is why we don't know what they are doing. I mean, we have all sorts of scary newspaper articles. Yeah. No, but the point is, the point that I'm just making is we've had evidence before us that says that the executive is flying up and down in business class. You know, I mean, all institutions are really taking the necessary precautionary steps to cut unnecessary expenditure. I just want to make the point that it's not only as a result of a funding model that they find, it's poor financial management. And they must pull in the ropes, and they must make sure that they stop spending so much. But yes, let's not talk about we can retain the technically insolvent, but let's say serious financial challenges.
That's fine, Chair. I was just going to say the main issue relates to the cash flow, and and the cash reserves. That is the critical. Those are the critical parts. The SABC's got lots of assets, so there's that. So I would be happy with that suggestion. I was also going to say there appears to be a cash flow challenge, given the significant deterioration in cash reserves at the SABC. Then we take the financial crisis words out. You got that?
So that we don't go around in circles, we must get to a point. We're agreeing that there appears to be a looming financial crisis, changes somehow to talk about serious financial challenges.
Serious financial
and cash flow, whatever the case might be.
And then I don't know if it's necessary to say, given the deterioration.
No, I'm just taking that point because you say something and then we agree and then somebody introduces something else and we go back. I'm just trying to get us to a point. The looming part comes out and we say there's serious cash flow challenges.
Do you want to end it there? That's
no, Killian had suggested financial challenges. Would you live with cash flow challenges here?
Cash flows are actually more accurate in
that's fine. Okay?
No, that's fine. I think let's agree with that part. But it goes back to one point, Chair. The AG was here. He appeared before us. I said, even the issue of cash flow, it's amongst the issues that the AG has raised. There are a number of issues that the AG has raised in the Auditor General's report. So I'm saying that I think what we need to do is to make an example, not only that part. It's not only the problem. There are many problems that the AG has identified. You know, so we have to, if we're to, I think we need to emphasize on the findings of the AG. Rather than, you know, because we'll pick up one and we leave it there, we'll pick up another one, we leave it there. Let's emphasize, because you're fruitless, it's the finding of the AG. Cash flow, mismanagement, failure to comply with Financial Management Act, and all of that is packaged into the AG's report.
But, Chuck, I agree with you, but we've already covered the fruitless and wasteful and those things. Is that fine? All right, you've got that, Cindy. Again, you'll have another bite tomorrow. What is the phrase?
No, the ad, given the significant deterioration in cash reserves, that is reflected in our report. So otherwise, you've got to qualify why is there a cash flow problem? Why do we say that? It's a finding, given the deterioration in cash reserves at the SABC.
That concludes the financial management as we have it. Is there any introduction of new financial management under the heading financial management and sustainability? Anybody wants to bring some other matter in that we'll put on the table debate? Because these we've done with, we're not going back to these. If you want to introduce a new one, you must be able to defend it. Honorable Mkwena, other members will listen and then they will comment and we take a decision. Honorable Mkwena.
Can we take a financial decision on dinner?
Our financial decision on dinner is that it's 7:30. That's the decision on dinner, 7:30. So any other one on financial management? Done. All right. The next one on page 70, let's just start by saying, honorable members, let's just start by saying the position as was when we left still pertains. So there's nothing else that has come, so let's not debate about it. The position is, the official one that we received was the one signed by the Minister, Yunus Karim, in 2014. There's been input from various people talking about others. We've not received any formal notification thereof. So that's the position. Don't ask me about that. Let's go straight into the business of this one. And you'll add to, if you want to add, or you'll edit what we have here currently. 2311, comments. Mkwena.
No, Chair. You know, so it depends now which MOI we're discussing here. Because it would appear that the MOI that we have spent 3 paragraphs on here was not even registered. So this discussion is fruitless. What we should do instead of discussing that MOI is to put in point form the minister's failure to administer proper documentation of the SABC. The most important point to be made about the MOI is that it confused the running of the SABC, even though it was not even registered. It was not an enforceable document. So the minister allowed the SABC to be run unlawfully under her watch, under a document that was falsely accepted at the SABC as as an official document. That is the first thing. Then I think it's important that we must also point out that the minister failed to administer the board membership. And we note the discrepancies around Hlaudi Motsoeneng being a board member in 2011, I mean a board of directors in 2011, when he was not qualified to be one.
Can I interrupt you?
Yes.
I'm not going to stop you. 23.2 talks about the removal and appointment of board members. I'm just saying, so that if you see the next one, are you saying they're all going to come under 23.1?
No. I'm speaking specifically about documentation now, because I think those issues we can then thresh them out later. But in terms of the documentation that runs the SABC, the minister failed completely to administer that. And that is the point that needs to be. In point form, we need to discuss, one, the failure to register the MOI, the amendments. 2, the failure to oversee the board membership according to CIPC documentation. What was the other one? There's quite a few, and I'm sure members will remind me of others. Thanks.
All right. So I'm trying to understand, are we dealing, should I allow people to talk on 2311, 2312, and 2313 all together? The whole lot, that's the suggestion. So I'll come to you. That's besides 2314. So the whole of 23, everything.
Because we'll have comments on sequencing of the
So
way.
on everything, including removal, everything is saying on everything. No, so everything on page 70. Thank you. So we will not talk about appointment and removal. We will not talk about suspicious documents at this point and those type of things, but we'll talk everything on page 70. Okay. You want to make a proposal? All right, make a proposal. Can members indicate that who wants to speak? It looks like, all right, everybody wants to speak, but let's hear, you'll be the last because you started it, obviously. But let's hear the proposal.
No, the proposal, Chair, was that can we have a 5-minute stretch? 5-minute stretch, because we are now going to be starting a new dimension in the whole MOI, just to stretch and pick up more energy. So I'm proposing that.
There's a proposal. Members must either accept or whatever. Remember, our formal break is at 7:30, and remember that you all agreed that nobody goes home until we're done with this thing today. So do you want a 5-minute break? All right, you'll be back at 7:30. You'll be back at 7:30. No, it's my watch says 25 past.
6:30, you mean?
No, I'm saying 6:30. We're saying 5 minutes. Oh? About 10 minutes. 6:30. Is it all right? 6:30. All right, we'll be back at 6:30. Mokoena, it's done. Deal. What do you want, Bob?
No, Chair, I think also this decision on 7:30 is not democratic.
7:30.
Yeah, that's 7:30 decision.
You want it earlier?
It must be much earlier. Now I'm
Okay.
extremely
Is it possible? Huh? All right, honourable members, let's agree that we'll try and bring it earlier, but we're working on it. We had already arranged for 7:30, but if we can have dinner a bit earlier, we'll do that. Yeah, at least finish MOI before we go to dinner. Yes, we can't break halfway. Mokwena's crying.
the legal processes in this document, they also said they must please stop.
No, I think we're going to change it. Honourable members, let's start. And can I make an appeal, honourable members? We try to be as thorough as possible, but I don't think we are being as productive as we should have been. We've had these documents. We had made an undertaking that by 4 o'clock or so we'll start with recommendations. It's almost as if we are reopening debates and discussions on these matters. And I've allowed it because members felt they want to do that. But can I ask members just to be pointed? I don't want it, or I want it, or I want it to be changed, or whatever. We really can't open the negotiations and remotivate honourable members. Maybe we can do that when we get to recommendations, because that's where we are. But if this is the pace that we're travelling on, just on observations, my fear is that we will be here on Sunday. and I'm being guided by you in terms of how we're going to proceed, but I'm just making that announcement, that we can't spend half an hour on one point, not even on one section, just on 23.11, we spend 2 hours, and we spend the whole afternoon just dealing with financial management when we've had this thing from the 3rd or the 16th of November. I'm just appealing to members that we try and be productive on this matter, because I'm determined that we're going to meet our deadlines. I'm determined that we're going to meet our deadlines. I don't see us coming back or asking for an extension at Parliament. A proposal.
No, Chair, there has been a particular practice that we used in the entire processing of our observations in the report till now, that we seems to be focusing on all of us on one thing. Why can't we go back to that area that members can identify in a page which areas that members wants to deal with, and we pass? If there's nothing to raise, why do I have to raise for the sake of talking? So maybe we can just put it as a page, the whole page, to ask a member if they have anything to speak on. Then we can close. We can still come back when we deal with the recommendation to refer to those pages, rather than this exercise would never end, Chair. So I'm proposing that you put it as a page. I take it that we have read the report as it stands now. Maybe we can put it as a page by page, and then we comment. If there's no comment, we leave it. Other people will do it.
All right, we'll be guided by yourselves. I'm just indicating that if we go at this rate, the downside is that we'll be here on Sunday. But that is your call as members. And we are on page 78, page 70. Honourable Mokoena had started the discussion, I think. Honourable Mokoena, have you water, if there's water for members? If there's water, if we could do that. Honourable Mokoena, I'm not sure if we stopped you halfway or had you been done. So, because remember, you're going to have the second bite after everything else. You done, sir? We haven't even recognized other members. You done? All right. Can we have an indication of who wants to speak on? And we'd agree that we're going to do the entire page 70. Speakers, anybody? Again, everybody wants to speak. Let's start here with Doc. Doc? 10 minutes a man, 5 minutes a man. Can we go to time limits?
I mean, it's a simple one, Chair.
All right. No, just before you start, Doctor.
We are on 23.1, hey. Entire page.
Yes.
Chair, I wanted to recommend that the committee notes that there have been 4 versions of MOIs, of which only one was found to be effective. I think it's going to be important to contextualize that, and then whatever else that follows, then we set the tone on that, because when we are talking about the amendment of the MOI, we are therefore saying it's that MOI that was found to be effective, or effectual. Sorry. Yeah. Yeah. Only thing.
Okay, if I'm understanding, Doc, she's saying we're moving from the premise that there's only one that is as the beginning. There's only one from where we're sitting now that is enforceable or registered or anything. Or that's legal, or whatever the correct word is.
The terminology.
And that one is the one dated 2013/2014?
Yes, we may put the date. It will be very necessary to do so.
That's signed.
Yeah.
I beg your pardon. Then we'll go down this way, and you can talk to that comment if you so wish. Yes, ma'am.
Thanks, Chair. Chair, I want to propose as follows. If we look at 2314, 2314 is trying to set the tone in terms of indicating which MOI is authentic. So I propose that we make that our first clause there. Subsequent to that, we indicate irregular amendment of the MOI, which is 2312. And in terms of 2313, we take the part which says the committee is concerned that the board, until we go to disregarded. In fact, we leave 2313 for further use. We don't include it here. It may constitute part of our recommendations because to me, it's pronouncing on our stance on the Broadcasting Act and the Companies Act. Thank you, Chair.
No, thank you very much, Chair. The opinion line which I support the colleague just spoken now, 3.14 becomes our opinion line. But I want to ask something out of order, Chair, that if it's possible, and I know that we don't have time to do this exercise, we needed to balance the attempted amendments vis-a-vis the current MOI that is standing, so that we are able to weigh in if there's any irregular in the attempt or in the current MOI as it's standing. Does it permit that amendment to have happened? Because here we are dealing with a number of amendments, moving of powers, directors being given powers and all of that. I thought maybe as we do this exercise, we can try and find a balance between the current amendments that we see and what is standing in the MOI. I'm not sure if you understand me, Chair, what I'm trying to put across. Okay.
Members will help us, Honourable Waters, then we'll go behind to Killian and we'll do our rounds. Waters?
Chair, support the proposal that upfront we state which MOI we believe is legal and binding. But where we talk about the Minister amending the MOI 2311, we said that MOI as it stands empowers the Minister. But I think here we're talking about the MOI that the Minister signed herself, right? So the fourth version, I don't know. Or right. So we've got to be clear which version we're talking about here, and we stipulate it. So everyone's clear. And similarly, in the next paragraph, 2312. Yeah, there as well. Then I just want to refer the members to clause 912, which is on page, I think, 33. Yeah, our document. I think it's 912. No, it's a bit further on. Anyway, paragraph 912, page 36. 912. But I'm on yesterday's document, it's 812, but anyway. So it says, during her evidence, the Minister insisted that amendments to the MOI were effective in accordance with both the Broadcasting Act and Companies Act. She stated that although legislation did not require to do so, the Ministry had consulted the Board on the amendments as a courtesy before they were submitted to the CIPRO, right? And that never happened. And I think we need to put that in as a finding. She stated in her evidence that she consulted the Board before she submitted the MOI, and she never did. And we need to put that in the findings. I think it's material, as well as the following sentence. You good? Okay, well, and then she carries on to say that she also briefed the Portfolio Committee on the MOI in June 2015. Now, according to the Minister, neither the Board nor the Portfolio Committee had raised any reservations. Now, again, it's misleading because we know that the minutes from the Board reflect that certain members had indeed questioned the amendments to the MOI. And so that also needs to be included here as a separate paragraph. Are you with me, Chair? So there's two issues. The one that the Minister stated she consulted the board before submitting the MOI to CIPRO, which she never did, and that there were no objections from the board, which there were. Yes, I think because they're both material. All right, thank you.
As long as members follow it, because as we speak, Mokoena, you'll be the last one, obviously, because you introduced it, and you'll consider the proposals made. Honourable Killian.
Chairperson, yes, I have been covered in some respect. However, I just wanted to make the following point, Chairperson, and that is, as we reflected in our current first paragraph, we talk of the Minister as the appointing authority, which the Minister is not. The appointing authority, according to the Broadcasting Act, is the President upon recommendation of Parliament. That is according to the Broadcasting Act. Now, the problem, the one that is signed by Honourable Karim, which is the one that is currently the only one of force and effect, has, however, two shortcomings, and I think we should reflect that. And that is, as far as the quorum requirement is concerned, which is prescribed by the Broadcasting Act, and the other one is confusion about the directors, their appointment and removal. There is a bit of a, and you see, the Honourable Muthambi, the Minister, has referred to that. But, Chair, and I think that is very serious, the amendments that were proposed and what the Honourable Minister made the board to believe, as well as the committee to believe to be the valid ones at this stage, the provisions of that MOI goes much further. That removes the power of the board to perform any role with executive appointments. And that is very serious. And I can demonstrate the clauses, but I don't want to go into the detail if the members are not interested. Secondly, it removes, it changes certain, can I say, definitions significantly. And it describes a much bigger interventionist role for the Minister in the operations of the SABC. And I think that must be noted. Again, I can refer members to specific clauses which she has changed. And that is why I have a concern about the current one, which is the valid one, and its ability to stand up to the test of the Broadcasting Act. But I have a significant concern about the one as drafted and amended by Minister Muthambi. And that one will have to be evaluated by the Portfolio Committee to see if it could stand going forward. So I don't know into what detail we want to go, but I think we must make those, we must express those concerns, because that undermines the role, the effective role of the board, if that is not amended.
You'll have to find a way of crafting it. Honourable members, can I just ask that I think it's like the other members have done. This is the point. I'm agreeing or disagreeing. Now, I hear Killian because you have to motivate it. But if you put it in bullet point, because when we summarize, we must be able to say, these are the 3 points that I'm agreeing or disagreeing with, without the motivations. Honourable Singh?
Thank you, Chairperson. Chairperson, the first point I want to make is we must start in the beginning. And the beginning is what was suggested by Honourable Khoza, that we as a committee recognize that there was an MOI which we have had sight of, signed by Yunus Karim and accepted by CIPC on such and such a date. That's the sequence of things. Secondly, I think we have to note here as a committee that during the evidence, the Minister insisted that amendments to the MOI were submitted to CIPC. She's insisted, on page 36, which Honourable Waters referred to. Then I think it's important for us to refer to this document here, the 3-liner, where On further inquiry, the committee was given a document which suggests, quote unquote, that the CIPC acknowledges receipt of a lodgement dated 12 March 2015. Now, my view is, and I don't know what the other members, that this is not an authentic document. It's not one that comes from the CIPC. And even if we accept it as authentic, it is not going to take the CIPC almost 2 years to register this amended MOI. It's just impossible that it would have taken them so long. So it's on that basis that I'm saying it's not authentic. It doesn't have a CIPC heading. It's addressed to Dan. We don't know who Dan is, whether he's an agent, who has power of attorney from the minister. So I think we have to agree that there is no other MOI that is of force and effect. From there, we then go on to the consequences of the MOI, quote unquote, that the minister purports to have signed and has been accepted, and the consequences thereof in terms of the actions that were taken. So firstly, we have an MOI, it's brought before us. Secondly, the minister says that there has been evidence of MOI. We refute that because there's no proof even until 4 o'clock this afternoon. Because surely they could have brought us something from CIPC saying, well, there's the signed MOI like the Yunus Karim one. And all searchers have indicated that there is no MOI. But I just want to go to the heading of that. Instead of amendment of the MOI, which creates a false kind of impression, shouldn't we just put MOI? And then we speak to the MOI. And wherever we speak of the MOI that we don't recognize, we put it in inverted commas, because it's not an MOI. There's only one MOI. And then we speak to the consequences. Thank you, sir.
Chairperson, no, I wanted to agree with the fact that 2314 should be our starting point, no matter how we phrase it, but should be there to show that there is only one MOI that is with the CIPRO, the one that was signed by the then Minister Yunus Karim. And just like Honorable Loliwe, I doubt whether 2311 has any impact, because to me that is just a prologue to the whole discussion. It merely talks to the fact that the MOI stands to empower the minister, etc., etc. So I would have just taken off that. Then we move to 2312. Then we add other issues that Honorable Singh and Honorable Koza have referred to. So that's my take, Chairperson.
Chair, thank you. I agree with what colleagues have said with regards to how we should craft our finding, but I think it's important that we also raise the issue that the MOI that was signed by Minister Karim also goes against the Broadcasting Act in certain areas, especially in regards to the appointing authority and the dismissal of directors. Now, what does that mean? Does that mean that MOI is legal? My view is it cannot. And that MOI is based even in the document that it is actually informed by the Companies Act. So in line with the earlier discussion that we recognize the Broadcasting Act as the act that applies in the SABC. What it means is MOI by Karim is not in line with the Companies Act, and therefore I assume that the Company Act prevails even. The Broadcasting, apologies. Broadcasting Act prevails when we have an irregular MOI. Yeah, so whereas in the latter discussion that colleagues have raised, we've raised the issue of the amendments. I'm just saying that even that one has got far-reaching effects, which is almost in line with the current ones in terms of the dismissal and so on of the people. So that one remains a problem. Yeah, I think I should end here. Chair.
Chair, yes, I agree with the other versions about the submissions as to we've got to set up front that in our view the Yunus Karim MOI is the one that is valid, and then we can go forward and deal with these other sections. But we need to deal with what was intended here, although it might not be a valid MOI in our view, we still need to ensure that the motive behind what was intended, in as much as change in directors of the board, is important to be captured. So, Chair, the Companies Act makes it very clear about the provisions for amending a memorandum of incorporation, and that's in section 16. And in certain cases, besides the resolution board, it must be filed. And that's what it says. And there are even where it might be a consolidated revision, you need to have a sworn statement by the director accompanying that revision. I don't know if these are considered consolidated revisions, but it's very clear in terms of the Companies Act what process must be followed for the filing with the CIPC office. So, Chair, I don't want to labor the point, but I think we are on the same page. Thank you, Chair.
All right. Just where we're not clear, 2311 as it stands now gets removed? And we're moving from the premise that 2314 is the beginning. We agreed on that one. I heard at least two members talking about 2311 is just a preamble or something like that. That's what we want to get clear. Which is the first bullet point after 2314? Oh, sure. No, we just, if it stays in, it's fine. We're just wanting to, so that we are clear here, because remember, we're drafting as you guys speak. Unless, this thing we've tried to recraft it so many times, unless there'll be a task team that will go and put this thing together, it's going to make me and Cindy's life and everybody else too difficult. You want to propose something, Mukwena?
Yeah, Chair, can I just throw the spanner in the works? And because what I think we should do is to outline the challenges with the company founding documents, the MOI being one of them. So we end with the MOI, and then we outline the issues around the MOI. I think it's important to highlight some of the changes that were made to the amendments that were made to the MOI, so as to demonstrate how the entire machinery of the SABC was then deteriorated. So this is what I've drafted, and I'm putting it to the House so that it can be right. But I think it's still in line with what you wanted to do. But it just adds the thing that I spoke to earlier on, which was at a separate heading. I call it Administration of SABC Founding Documents. Yeah, I'm suggesting that it be the first one. The first heading. Yeah. The first heading becomes Administration of SABC Founding Documents, right? And I've drafted 3 points under that heading. The one is the minister failed to administer the SABC founding documents effectively. An inquiry into the CIPC revealed questionable enrollment of both Mr. Mutsueneng and Mr. Geldenhuys in 2011 and 2012 respectively, when there is no explanation for this action. That is the first point. Second point, the minister failed to register the amendments to the MOI in 2015. It must be noted that the minister made a written submission that such was registered. According to CIPC records, the last MOI to be registered was in 2013 by Minister Karim. This renders Minister Muthambi's MOI not enforceable. That is the second point. Third point, the minister allowed a delegation of authority framework document that was based on an illegal MOI to be the regulatory framework for the SABC. This rendered almost the entire operation of the SABC legally questionable. So that would be under just administered. These are founding documents. It's the directors, it's the MOI, and then it's the delegation of authority framework. Then we move on to this MOI. And I think that heading should then be the weaknesses of the shareholders' MOI amendments. And then we can then go into what it is that we picked up about that MOI, because I think we must highlight how the SABC was, and then we'll start with that point that you were going to start with. And the first sentence would be that, again, maybe I'm just laboring the point. The first point would be that there were four MOIs, and the only one out of the four is that one. And then we'll go into point 2.23.1.1 as we're discussing it now. But I think it's important that we must start with these other documentations. We must put them in there.
All right, there's a proposal. I mean, there's just one thing that we must guard against so that we don't, you know, the 2011 and 2012, the current minister was not the minister at the time. So when we say the minister did X, Y, and Z, you're either going to have to say which minister, because 2011 and 2012, the minister wasn't there. Yeah, so, and that is why I'm saying, honorable members, you know, and I repeated this yesterday, I really think what we should be, and we can put it in all, whatever way you're putting it, the real observation is that the whole administration or lack thereof and so on has created lots of problems for us. Now we could put as examples what you're saying, waters, and the beginning point. Unless somebody is going to go and craft it for us, it's going to be very difficult. But certainly, if we refer to 2011 and 2012, you can't describe that to Minister Faith. That's another minister. So those are the complications. There's at least 3 ministers that we're talking about in this process. And I'm not disputing what you're saying. I'm just saying from a practical point of view for this document. Yes.
No, I think we can be specific in naming who was responsible and so on and so forth. But I think here, the administration of SABC documents, that is the heading. It's not to say it's Minister Muthambi's responsibility. The entire administration of those documents is wrong. And then when we go into specifics, we can then specify that Minister Dinapule did not do this, or Minister Karim this, or Minister Muthambi failed to do this. Thanks, Chair.
To that, because whilst I agree with the sentiments, honourable members, I really do. I just don't know. I'm looking at the researchers and everybody else. It's going to take us a whole 2 days to do that type of thing. And if people have it, no, it's fine. If you've written that whole exercise down, then it's fine. We can distribute it to members so that they can clean it up and patch it and do whatever the case might be. But we can get somebody, Mabasuto or somebody, to make 7 or 11 copies for us on that one. Everybody had spoken on this thing. We had given it to Mokwena because he started it for him to close it. I'm not sure what are we saying now because he, as he said, he brought the spanner into the works after we'd agreed on what was first. There's an introduction of a new subject. So I'm not sure. And it's a pity that you were the last one. When I say a new subject, I'm saying a new heading, not a new subject. Members had not had that part because that's a new proposal. It was not what you said earlier on. Did you say that?
No, I honestly think that all the points
That's good.
are still valid.
No, it's fine. That's why I'm saying craft it, or somebody must craft it for us. I have no problem. Somebody must just put it together for us. Let's take Loliwe, small one and a small one, and a small, when I say small, 1, 2, 3, 4, 5, and Mabasutu just be on standby to make a photocopy of whatever Mokwena has. We can always revisit it just now. Loliwe?
Chair, I need to be clarified here. Honorable Mokwena introduces a new heading, which is administration. Is administration of SABC the responsibility of the board?
No, Chair, we can't call that, we can't call that, Chair, a administration of documents. The heading is correct, it's MOI. And therefore, under MOI, we then have all the subs as he puts them. But there's a point that Honorable Mahlangu raises, that in fact, even the Yunus Karim MOI, it's against the Public Broadcaster Act. And I'm saying that we need to go deeper, therefore, Chair, in looking at which areas, because you then find that the current minister, in fact, implemented some of, this is a point I made earlier when I started, should have implemented some of the decisions implemented may be informed by the Karim MOI. So I'm saying that in that work that we're going to do, if you can expand further and to look into the status and the decisions that were taken under that particular MOI, it will help us a lot. Then point 3.12, Chair. I think we have agreed that we're going to leave the paragraph as it is. But I want to propose that, because there's never been any amendment other than that amendment that we talked about of 2013, that the irregular amendment, we take it out, we use an attempt to amend the MOI, that line. We take out that irregular amendment of MOI, because it was never amended, approved, by the way, meaning that lodge and then approve. So we simply put the word attempt to amend the MOI. All of that, it has been an attempt which was never lodged with CIPRO, you know. So I thought we just take out the line irregular and use an attempt to appeal.
I'm going to take a decision after Singh and Swartz. We're just not going to be bogged down on, not Singh, I beg your pardon, Singh and Swartz. We just have to find a way, honourable members, that we deal with this matter. Other than the introduction that you've done. Yes, sir?
Chair, I do support the fact that we should chronologically, state what happened. And whether we call it the MOI or whatever, it's neither there, as long as it's in the document, quite frankly. But, we're confused amongst ourselves, and we've been dealing with this for weeks and weeks and weeks. Can you imagine if someone reads a report? We've got to make it as clear as possible. So the issue about Mr. Motseneng and the Mrs. Geldenhuys becoming directors is important, because I think it shows intent and it shows a concentration of power and an agenda, even if it was a Minister Pule, so I think we must do that. I do support the fact that paragraph 23.11 stays in. I think it's very important. I don't think we should remove it, as been suggested by some members. Again, it shows intent by the Minister, 23.11. It shows intent by the Minister to consolidate power and to influence SABC's administration and independence, as we state there. And then, as far as the MOI under Minister Kasim is concerned, Karim, The fact is, I don't think we can't go into too much detail about it, saying this section transgresses the Broadcasting Act. I think what we must do generally is state that we feel it does transgress the Broadcasting Act, and that whoever's going to do these investigations that we're going to suggest in the findings, that they then probe that particular MRI. I think for us to stipulate everything here is going to, we'll be here all night. We'll be here till next week, quite frankly.
Honourable Singh.
Thank you, Chair. Chair, you made a proposal earlier on that Honourable Makwena's drafting let it be sent to Cindy and let's get hard copies of it so that we can look at it and propose amendments to that. Then we're working from a document, right, that we can amend. Now, I will propose some amendment which is in the air, Honourable Waters will propose something else, and I think it confuses you at the table. I have certain comments that I want to make to his proposal, additions and possible deletions, but let us do that in a very structured manner. And I suggest send it through, and then this whole paragraph on MOI, we can leave it for a little later. We can continue to deal with the next item, next sub-paragraph. Thank you.
Doctor?
Yeah, first of all, I must apologize. My son is at the university for the first time, so he's disturbing me. He keeps on phoning me. It's the first time he's away from home. Chair, I wanted to say, Chair, I want us to revert back to the way you were running this meeting previously, where you allow us to speak for 3 minutes, because I think other members, it's like we are redoing this document. My understanding was that we are going to be focusing on those areas that, are so significant that you can't live with. And the arrangement and the chronological sequencing of, of the document or the flow of the document, basically. And Chair, I think we are going in circles. And again, in as much as I heard what Honourable Mokoena, and I'm so sorry, Honourable Mokoena, I only heard the earlier part of what you said. The latter part, I didn't hear it. Honestly, I don't know why we should have that suggestion from Mokoena that talks about the founding whatever of SABC and so forth. I honestly don't think we need to go there. And I do think that 23.1.1 captures the essence of what we wanted to say as an assertive statement. And we had already agreed in earlier drafts with this. And Chair, if you could control the way we do this thing, please.
We will do that. We're not touching MOI until we have a hard copy before us. Honourable Mokoena, you will, when you have something, send it to somebody here to go and print it, even if it's a standalone. We won't touch it on our report, Cindy. We'll discuss it and then decide how we're going to put it in, but taking into consideration all the points that have been made by the various members, and we'll discuss it. So can we say that about the whole page 70 until we've got a document? Yes. All right. Hopefully we can, before 7:30, honourable members, deal with, I beg your pardon, deal with 23 to 1. And I'm reverting to the way we managed it in the past. You're not going to get 2 bites of the cherry. You're just not going to get 2 bites of the cherry. And we're going to limit it to time. So we're dealing with what we have on page 71. People must talk to whether they're comfortable with it. If you're not, what are you comfortable with? No narrative or what you want us to put in. Please tell us exactly what you want us to put in and we'll put it in. We're really not going to go to any motivations because we're observing, we'll motivate at recommendations. Everybody's got 3 minutes. You need less than 3 minutes.
No, but that's the max. 3 minutes.
Okay, no, 3 minutes is the max. Okay, 3 minutes is the max. If you can do it in 1 minute, it's fine. We'll start this side. I beg your pardon. We're reverting to the way we worked in the past. Excuse me. We'll start with Swartz, Mahlangu this way, and if you don't want to speak or you covered, you covered. we're going to be as ruthless as that from now
There's-
on. Yes, sir.
There's only 3 clauses here. It's very straightforward. I agree with the clauses as they are there. The only words that I would reconsider is 23.2.2, the words covertly or overtly. I would rather say directly or indirectly. And then there's no section 96B in the Constitution. It's 96.2B. With a 2B. That's it. 20 seconds. Thank you, Chair.
Mahlangu, is there anything you want to add, sir? Honorable Mahlangu? Prof?
No, it's fine, Chair, except that on 2323, I would have also added any other related legislation
Whereabouts?
towards the end of 2323.
After Privileged Act?
Yes,
And any other legislation?
and any other applicable legislation.
Applicable legislation, that's fine. Honorable Singh?
Yeah, Chair, I agree with the proposal by Honorable Swart, directly, indirectly, and the applicable legislation in 96.2B.
I'm not sure, Mokwena, because we are disadvantaging you now. You're focusing on this and you're not going to be able to participate. Oh, you covered. Oh, it's covered. Okay. Waters?
Support the Honourable Swart's amendments.
Thank you so much. Killian?
Support, Chair, nothing to add.
Lolewe?
Support, Chair, but don't forget, the team should not forget what Mr. Singh said earlier on in the original document. The dash there should at least move away so that it becomes a proper sentence. Thanks. 2321.
All right. Thank you, Chauke.
Chair, and are we at 413? I'm proposing that we need to note the. No, give Jampile, sorry. No. I've moved very fast, Chair. I'm already at 4.13. Sorry, I've moved very fast. Then I'm.
Honorable Dr. Koza?
Impressed, Chair, with the efficiency of members now. Thank you.
Thank you. Yes, sir?
On page, on 2313, the fourth line. 2313. Oh, you still at 2312? No, it's, are we not dealing with the whole complete set?
No, we're not.
Oh,
No, we've said that one we're not dealing with until we have hard copies. No MOI discussion.
okay.
No MOI discussion. Honorable members, we're moving on. Thank you very much. Maybe you'll deal with the heading as well. I mean, that's the heading that we have here now. Suspicious transactions. Maybe we'll change the heading when we go on. Page 71. Honorable members, really, those just highlight everything else, and there's no other thing we can do. But so I'm suggesting we do it all of them up to 2416, eh? 2416, eh? Yeah, up to 2416, all in one batch, because I mean, all it's doing is just giving us the different role players, but it talks to the same thing. Who wants to take the first bite on those? Or do you want to read it for 2 minutes before you take a bite? Yeah?
Honorable Swart.
Oh, you want to go first, Mr. Singh?
Let's ask Honorable Swart, because it would seem that his suggestions are finding favor with many of us.
No, it looks like Chauke wants to start this time.
I'm going to start at the bottom, Chair. Is it fine that I start at 4.16?
Yes? No, but we thought we'll deal with all of them collectively. We're not going to allow you to do
only have
one by
one point.
That's fine, that's fine, yeah.
I only have one point.
That's okay.
The point that I have, Chair, is around the multi-choice transition that is subject of the court. Not was. I think the matter is still at the court even now. It's not finalized. So we put is rather than was.
Only change you're going to make on that one, and you agree with all with all the other observations as we have them. Okay. Anybody else other than Honorable Chauke that wants to speak? Honorable Singh.
Yeah, Chair, on 2413, I would suggest that the committee could not establish with certainty, not with confidence, with certainty.
2413, the very
Line
first
one.
line, we remove confidence and we put certainty.
Yeah.
Honorable Dr. Koza?
Chair, I wanted to suggest that we remove suspicious transactions and rather say questionable transactions.
Anybody else that wants? Honorable Killian?
Yes, Chairperson, it's just with regards to the very last paragraph, 24.4, Foxton Communication. Are we there as well? Oh, okay. Are we just dealing with multi-choice?
I thought members said we're going up to 2416.
Okay, good.
Okay, no, that's fine. So, honorable members, 24, you see you've got 14 instead of 24 there. 20, we've got 14, we'll change it to 24. From 2411 to 2416, the tense was turns to is, and the heading to questionable, and was there anything else that we picked up? That's it.
Certainty on one.
Uncertainty. Okay. You want to take a bite now, Honorable Swas? Yes, sir.
Chair, there's a lot in the SABC's response on this multi-choice that we now are aware of. Whether we, how we gauge that now is the issue, because they say, for example, on page 111, and we reflect that in our document now, on page 55 of our document, where we set out, clarified that the channels will revert to the SABC platform. So in other words, we now know the certain facts, and we also now know on their version that only 1% of the archive material was part of this process. Can we now say that the committee could not establish whether the content remained in the SABC's possession? Is that a correct sentence? I don't think so. I think we've got to weigh up that fact. And so it's, we must change our wording slightly to say, well, to 24.1.3, the committee could not establish with confidence whether the content of the remained in the SABC's possession. So we've now got facts to say it is there. We can still say, well, we don't know whether we can accept that version or not, but we have referred to facts in this document. How do we deal with that is maybe just change the wording slightly, because our recommendation is going to be that there should be a further investigation into that. So we don't have to conclusively, with absolute certainty, say that. So, Naren, how would you change that first sentence just to with confidence, with certainty? Well, I can live with that as it is now, particularly in view of the fact that we've still got we've got a version of the SABC here, but we're still saying, well, we're not sure, with certainty. We're not saying it's not so. We are saying there's going to be further investigation about that. And that, I think, is fine, Chair. That's fine. That's the one point. And then just the last paragraph, 24.1.6, I think there was the subject of a court case. I think there's various court cases. There's Competition Commission, and I think there was something before the Constitutional Court as well. So maybe we should just say was the subject of litigation. Yeah. Litigation, because that covers whether it's one or various court cases. Is the subject of litigation. Thank you, Chair.
Chair, I took the view that the committee was not persuaded by the arguments advanced by SABC. And to this stage, we are not absolutely certain about the multi-choice contract, and to the extent to which you know, the public, the asset remains the public, because you must understand this, structuring these deals can be very, very complex, especially if we are trying to subvert from a particular legislation and so forth. And I will be comfortable with remaining with what we have, because that will be subject to more investigation with people who are competent to actually come to a definite decision. But this is our view as a committee. We are suspicious that somehow the public has been shortchanged.
I think,
Yes, I am done.
I heard Mr. Swart saying fine, so I think there's no need to pursue the matter.
Yeah, but I think the point we need to make for the public and records is that we have taken into consideration what the SABC has said, notwithstanding that this is our observation, still our observation. So we don't want them to think that we ignored what they've said in what Honorable Swart referred to later on. We've taken that into consideration.
Okay, I'll keep on reminding members that ours is inquisitorial. If there's sufficient reason for us to refer it for further investigation, then we've done, because we're not saying anybody is guilty or innocent or anybody was whatever. So the road doesn't end here. As long as we don't say things that will create the impression that the road ends with our word.
With certainty, as opposed to with confidence. Certainty, that we just change that.
That's what I'm saying, yes, yeah. That's what we're going to do. Anybody else on 2411 to 2416? No. Done? Thank you. 24, again, we've got 14. It should be 2421. Any comments? Page 72.
Except for just the numbering, which is a typographical error, I think, or a cut and paste since, you know. We have 2.24.2, then you have 14.2.
Looking at 2431 for now, we say the committee notes with certain. Is
With consent. With consent.
Oh, I beg your pardon, with concern. Yeah. Oh, I beg your pardon.
Yeah, exhausted.
Sorry. All right. Mr. Singh?
Chair, Happiness, we just got to remove that dash there on line 2 of the first one, that the evidence suggests. And I think we are saying this because we'll make recommendations on these two things. That's why we're saying it, put it the way it is. Thanks.
Can we move on? You're moving on, Prof, or is it on the, on 2441, no?
It's just a minor.
Yes, sir?
24.41. Ms. Dlamini in the affidavit, not yet. Okay.
Oh, you can start there now, because we've done with that. Oh, you still want to talk? Okay, Mr. Swartz?
Just,
Oh,
Yes, ma'am? Are you going to say something on 24?
are we there? 3.1? 14.3.1, are we?
2431, I thought we dealt 2421
The,
and 2431 together, but if you want to add to those, you can.
the evidence heard, we just take out heard. We've always said the evidence suggests. We don't have to say the evidence heard.
As you, Prof, on 2441?
no, the sentence should be Ms. Dlamini in the affidavit she submitted.
No, take the out.
Take the out.
All right, I think we're there. Anybody else wants to talk to 2441? And that's one of those that came from the one-pager yesterday.
I think that Foxton communication. Is it the name of the company? Foxton Communication and not Foxton Communicating? Is it? I'm not sure.
Cindy assures me that it's communicating.
Oh, the name
But
of the
we'll check the wording. We've got contracts for those things, but she seems to be comfortable that it's communicating. We'll confirm it. Letabo Hazo is. Oh, he's confirmed it. That's fine. Anything else on 2441?
Chair, that upon the publication of the interim report, was the report, it wasn't published. I think we should say following the release of the interim report. It was sent to certain people, it wasn't published. It says upon the publication of the interim report. We should say something like following the release of the interim report.
Right now, 2441, anything else? Yes, ma'am, Killian, and then Swartz.
Chairperson, I just thought that we should say Ms. Lamini in her affidavit submitted to the committee.
It's 2441, sir? Yes, sir?
Again, sir, I don't understand what is our attitude, what is our finding, because we are regurgitating what they told us.
Further investigation.
It doesn't sound like a finding. It sounds like it should be in the responses.
Doc, then we'll come to Prof.
No,
I mean,
I'm not
to-
sure
to-
if this will assist Honorable Mukwena. It's under the heading questionable transactions. And then if you say that whatever that you have there, it's within that. In other words, that's what we are saying. We are saying it's questionable.
No. Let's clarify it. Cindy's trying to explain. You'll recall we received from Ms. Lamini, that's why we put it as a one-pager. Originally, she said 350, Ms. Lamini, and we put it in as 350. Mr. Foxton came back and said not 350, 75 plus whatever, and gave us the contract. Now, we couldn't go back to Ms. Lamini's one and change it and correct it. So we had to record it somewhere. That was the reason why we were putting it here. Because yesterday we wanted to fix up Ms. Lamini's one, and people said, no, but that's not correct because that's what Ms. Lamini had said when she did it. But the fact of the matter is now we've got a corrected one with a contract and with everything else. We can't not somewhere acknowledge that we've got it. And this was attempting to do that. Yeah. Is that okay? Yes. Yes, thank you. Yes, Honorable Muthambi.
Should we say clarified or disputed? Because Foxton disputed the figure.
No, he clarified it because there was a contract that we were given. We've got a contract to that effect. So it was, for me, it's giving clarity as a,
I'm agreeing with,
The word clarified or disputed, I thought it was just bringing clarity because there was something that was put, and it was put by the understanding of an individual. The person with the correct stuff comes and says, no, actually that thing is not correct, this is the correct one, and he has proof of evidence. Yeah. So if you want to put disputed? No, I'm not answering you, I'm just giving the context as to what it is. Members must decide. Loliwe, the question is to be used clarified or disputed.
Thanks, Chair. Chair, to me, Mr. Foxton clarified what was said by Ms. Dlamini. So I think we can live with clarified. I want to lobby my learned friend over there, Honorable Mahlangu.
Chair, I think we can live with that.
With that? Thank you very much. Yes, everybody? Okay, we move to page 73. Okay, 73, I've noted Water. Can we ask you, Honorable Waters, and everybody else, that you're going to deal 2551 and 2552 if you've got both. If you've only got 1 point, it's 1 point. We're going to deal it in that fashion so that, supper's come and gone.
Yeah. Chair, I wanted to bring in 24.51 or 24.5.
Oh, you wanted to bring a new one? I beg your pardon, we had said new ones, yeah.
And it's just got to do...
All right, hold on. I should have said that. After that new one, we'll break for lunch, because on everyone we'd asked, is there any new one? So,
Dinner, huh?
I fall for dinner, I beg your pardon. Honorable
All right.
brings under that topic of, what is it called now? Questionable transactions, you want to introduce a new...
Yes.
Yes, sir.
Chair, Mr. Shushu gave oral evidence and written evidence. And in his oral evidence, section 721 of the document, of our document, he also mentioned questionable contracts or transactions that included Talent Africa, and he gave a detailed description, Laura Vision, and he also talked in the written, in his oral submission, he talked about Mr. Maguma, who had was involved in a questionable transaction, as well as the head of SCM. Right, and we haven't stipulated them. And I was just wondering, we've stipulated the others, so why are we excluding them? And I'm not saying we should give maybe a whole paragraph. We could say, Mr. Shushu gave evidence of questionable contracts or transactions in relation to, we can just name them, that's all. But in his written reply to us, he added a few more in, and he gave us quite a lot of detail, if you remember, from page 20 to 30. And he also included companies that's Lezef, I've got Laura Vision, okay, PricewaterhouseCoopers, procurement consultant Miss Markizi, Mott MacDonald, Asanta Sana, and the RFP book content acquisitions, and also a company called SKX. So as I say, I don't think we should give a full detail of every single one, but I think we should mention them at least in one paragraph. Because if we don't mention them, that means we don't think they are questionable and will not be investigated. Okay. Yeah. Right. Okay.
Well, Honorable Waters, if you go to page 60 of our document, page 60 of our document, you mentioned more than just those that are on page 60 of our document, 1741, isn't it?
Well, I'm comparing his written and his oral. So yeah, there's a few more.
His written and his oral. All right, will you list them for us? Because it'll just, but we take the point that we should list them in one paragraph. Yeah. Okay, but just make sure that we don't leave one out of those. So between, yeah, yes, ma'am. Yes, ma'am.
Can I check with the sponsor if then there's a page where we are listing what Mr. Shushu spoke of? Will we be changing the context in which he was raising that if we put them on page 60? Because I think even with the ones that are listed there, we never received anything which is either confirming them or whatever. I just wanted to check that. Can I repeat? Chair? I'm saying there are transactions that Mr. Shushu is alluding to as captured on page 60. But he further submitted other transactions. Why don't we then put his package in one place by taking what Honorable Waters is raising into page 60 so that it's clear that we have reflected on that?
Get them onto observations as well.
Yeah, I think we should note them under his submission, and then and also put them under observations. I think questionable contracts, just name them and not describe them.
All right, so that's the additional point one. Is there any other additional points under that transaction? Because remember, honourable members, we're saying that this is way beyond our capacity. We'll hand it over to somebody else to investigate. This is just a kombandlela for whoever we're going to give it to. Honourable Muthambi.
Chair, Chair, I think we should find a way of, look, I would suspect that Mr. Shushu would have raised a number of companies, as it were. But would you say that is exhaustive? My view is that in view of what Chauke raised the other day when we met in S35 or S12 about something that is in the public space. I mean, the incidents that happened, alleged to have happened ahead of December, Christmas, what you call, which we reflected on. Well, someone can say, but we may be chasing unnecessary, what you call, matters. But it's a matter that I think, in a way, we should craft, especially to say some of the things have come to our attention through the media. For instance, if it's necessary, or we say because it never presented, but I know that we reflected on the matter in one of our sittings. I'm just saying we need to, perhaps if we could find a way, if it is possible, to raise that matter, because in our recommendations, it would be crucial that we allow whoever will come in to actually spread the wings. Because I honestly believe that there are many other things that has not come to our attention. If there's a way to craft such a statement, I'm not the best crafter in this regard. Even if it's one sentence that would deal with the matter, Chair. Mr. Swart can help.
We can't speak.
Honourable members, I don't know. You know, as you say, and this is the difficulty that we have. Once we start listing, you're either going to say, and others, or you must be exhaustive. Because somebody that takes it is going to say, you've only given me 10 names, I must do 10 names. That's the difficulty I have. And I'm looking at Honourable Waters, because yes, those are the ones that one individual gave us before us. There might be, as you're saying, other ones. How do we craft them? Because, look, let's be clear on this one. I think we're all on the same page. Our recommendation is going to be contract management must be cleaned up. So contract management is going to cover, if it's done thoroughly, it will cover all the contracts. Do we have to put it here? That's the question that I'm asking.
Well, Chair, okay. Well, the question could be asked in why we're mentioning some and not others, right? So if we do list these ones that I'm talking about from Mr. Shushu, then we can also say at the end of the sentence, but not limited to. And that just, it leaves it all open.
This is not exhaustive.
Yeah, that's what I would suggest.
That's exactly what I was going to say. Chair, that is what I was going to say at the end or at the beginning. If it's at the end, you say the above is not an exhaustive list of questionable agreements, contracts that may need further investigation.
Satisfy you, Honorable Matang. Thank you very much. Anything else under questionable contracts? Otherwise, we're going to break for dinner for half an hour. Are we done with that? We'll come, Minister. Okay, honorable members, it is 7:45. 8:30, we'll be back here to deal with 2 pages and get on to recommendations. Is that okay? All right? 8:30 sharp, we'll deal with these last 2 pages and get on to recommendations. Dinner is in Mark's building, right? 8:30, 45 minutes? 45 minutes is fine? We always have an hour, and by the time we get there, it's already 15 minutes. 25, 26, 27. Why do you go back to 23? Oh, am I seeing it wrong? Yes, sir? Members, can we start? Thank you so much. We've got still 4 points from 25 to 28, and we must go back to MOI just now. And we have to start recommendations today, honourable members. We're going to continue with our strictness, because I'm sure these are not too contentious. I hope they're not too contentious. Honourable members, we are on page 73 of our document. Can we, in the same vein, do 25.1.1 and 25.1.2? So when you have the opportunity to speak, you speak to both of them, or you speak to the one you want to speak to. And once we're done with that, we will indicate, or you'll indicate if you want to add to. There's only 2 bullet points. Honourable Killian, I note you want to speak. Anybody else at this point, or do we just start with Killian, maybe? Honourable Killian, yeah.
Chairperson, I believe that we should have paragraph 25.1.1 and 25.1.2. When we come to additions, I would like to make a proposal for one further element, which will follow naturally on 25.1.2.
And to put that one so that as people speak, they speak to that one as well?
I will do that, Chairperson. Chairperson, I believe that we have referred to the one person who was appointed where we had an adverse finding. I think what we also need to put on record is it appears that the appointment of the company secretary is also a matter that needs further investigation. It is a position that can only be appointed by the board, and there will have to be some clarity about when the board was correct to make the appointment of the so-called deputy secretary, because if you will recall that the minutes that were presented to us still had Ms. Theresa Geldnys as company secretary and deputy secretary, the current one, and we will have to investigate that because that would be highly irregular as well. So I think we must just make the point that the committee notes with concern that some internal changes were also effected, and that the appointment of the current company secretary, no evidence exists that the appointment of the company secretary was done in terms of the memorandum of incorporation.
As other members speak, you'll speak to that point. There's a suggestion that we add the fact that the then acting is now permanent, and questioning the process that was followed, I guess is what you say. Honourable Singh.
Yeah, thank you, Chair. I just want to know, for clarity from Honourable Killian, whether that came out in evidence or from documentation, and then on what basis are we making that observation? Is it something we are observing on the outside, or did it come up in evidence?
Chair, just a quick point, 25.1.2, where we've got the COO, can we please put Mr. Mutsaneki's name in there, please, for clarity.
Chair, I don't know whether we should zoom into the positions. You remember earlier on we dealt with almost a similar matter, and we referred to the, well, I don't know whether it's senior management or exco, whatever, because I believe we hold a view that quite a few of those people, there are people that were appointed who actually came in acting position and were confirmed without following procedures. So I would be weary if we start to put, in the same way as we dealt with the last matter when we concluded, I would really, perhaps because we're going to recommend for an investigation, that we actually allow it to, broaden the scope at that level. We would know that even, the lady who came here as the secretary got appointed as GC whatever, and it happened now, and I doubt if there were any advertisement and so on and so on. It's just, we've got those and so on. I think let's not try and pick up individuals, let's just have a general approach.
Chair, I wanted to say, first of all, I think we should revert back to the rule that we had accepted, that a member will have to speak for a maximum of 3 minutes. And two, Chair, I'm not sure if Honorable Killian really wants us to go into that detail at this stage. I feel as though 25.1.1 covers us somewhat, though I would like to amend all levels to saying probably almost all levels. The reason being that we were not privy to all the levels, but we are inclined to believe that it may have affected almost all levels, because based on the prevalence of those that we had seen.
Honourable Killian, you'll take note of these things and you'll be the last one after everybody's had an opportunity. And remember, I'm again being reminded that it's, excuse me. You are reminded that you have only one bite at the cherry. Prof?
It's a small thing, Chair. I don't know whether I can speak on 25.1.2. Yeah. The sentence that says this points to the board and or its subcommittees failure to exercise effective oversight. Towards the end, the sentence says in relation to matters of financial and human resource management. Now, the topic is about human resource management. I would have wished that human resource comes first before financial matters to strengthen the context.
Any other takers? If not, just if we go back, honourable members, to the letter that we've received. I'm not sure if did we share that letter? The second letter that we received was almost what would you call it? Almost an assumption that we're reading those judgments incorrectly. If you read the letter, I'm not saying we need to agree or not with the letter. From Majavu. I'm asking that question because we're saying here, who had an adverse finding now by the courts. Now, that's what I thought it was, an adverse finding. But if you read that letter, it's almost putting questions that, no, it's not actually that, it's suspension and so on. I'm just asking the question, must we be so, or do we say a finding by the court? I'm not sure how we put it, but I don't feel strongly either way. Yeah, that is on 25.1.2. If we're comfortable that that is what the court ruling can be interpreted as from our side, then I'm comfortable with it. I'm just asking the question in light of the correspondence that we received today. So that's just my addition, but let's leave it to Killian. You've heard some of the comments that members have made. Do you basically stick to the point that we should add your third bullet point?
Chairperson, if I'm in the minority, then obviously it's not going to fly, but I would have suggested, you see, if we speak of almost all levels, it's not as serious, well, it is serious, but you know, we're talking of senior management positions. We're talking of positions that should go through specific processes, and I mean, there is a differentiation. So clearly it is a matter of great concern, and if we are getting people who are in acting positions just assuming, that is what Honourable Mashlangu has also said. So if we should not specify the company secretary, then we can leave it, but then we must refer to people in senior positions, in executive positions or in management positions. Well, and yeah, I would have suggested the company secretary. You will recall, Chairperson, that we got company secretary correspondence at the beginning of the process. And thereafter, at the conclusion of our process, there's a new company secretary. Who appointed that person? So, yes, if we say, did we have evidence to that effect? Yes, we did. And Honourable Waters or somebody asked a question. You know, we certainly have evidence to that effect, that there were changing of individuals in specific positions before us.
Can I just go back to 25.1.1, honourable members? If we read the sentence, and if we took out the words across all levels, just took it out totally, a number of irregular appointments and dismissals within the SABC, and we take out across all levels, then it takes away the fight, isn't it? Yeah. Okay. What are we saying about specific reference to the position of company secretary? Just on that one. Yeah, 1, 2, and 3.
Well, Chair, the company secretary gets appointed in terms of the Companies Act. So he does not necessarily form part of the normal staff of the SABC. Therefore, mentioning that position therefore becomes crucial. It's a standalone position.
Yeah, Chair, I think we should mention, it's an important position, we should mention that. But just while I'm on the floor, I think we must also mention Mr. Motsaneng's name, because he is certainly quite central to this entire thing. So.
Chair, my view is that if we are going to be mentioning the names, we have to mention at least all the key individuals that came before us. That's the bottom line. Because if we are going to be mentioning Motsaneng, then we are inconsistent. You understand? Whilst I understand the position of the company secretary, because there is a special legislation to how a company secretary should be appointed. But if it's really the other staff members, I mean, I would recommend that we possibly mention all of them. Because how do you leave some of them out?
Thanks, Chair. Maybe up there where we have mentioned the COO, we need to put in something which says including but not limited to the appointment of the company secretary, so that we cater for what Honourable Khoza is raising.
You're adding it to 2.5.1, you say?
In 25.1.2, Chair, because there we have mentioned the position of the COO, I'm saying let's find a way of expressing there that it was not that position of the COO only. It includes, but not limited, to the appointment of the company secretary.
Yeah, Chair, you know, early on you said we must be able to live with this document and bite the bullet, and we should not obfuscate. I mean, the fact of the matter is, who are the other people that we are referring to that we have not mentioned in name? I don't think there's anybody who was the subject of a court order with an injunction that what the board did was wrong in terms of the appointment, and also the subject of a public protector finding. And I see no harm why we should not mention Mr. Motsoeneng, because he is the person, whether we like it or not, you know. So it will just strengthen our recommendations, I think, when we make this observation, because it arises from a court order and a public protector's finding. So I support Honourable Waters.
Persuaded, Chair.
All right. So that 25.1 will have 3 bullet points. 1.1, 1.2, and 1.3 that talks to the company secretary. Is that what we're saying? Is that how you have it? Or are you going to include it somewhere? Okay. No. We'll use both. Okay. Do we want it as a standalone, or can we include it in 2.2, honourable members? You want it as standalone, the company secretary position? Standalone. Thank you. Anything else on 25.1? No? Excuse me. I'm sorry. 25.2. 2.1 and 2.2. Again, I was going to do what I think Mr. Swartz is going to do, but let me start with you, Swartz. Maybe I'm preempting. Say again, sir?
No, it's okay. I was just going to suggest 25.2.1. Professor Maguva went to the extent of expressing ignorance of their labor dispute. Did he not also express ignorance of the threats? That he wasn't aware that there were threats against him? So it's not only, I think I put those specific questions to him, if I remember correctly. Express ignorance of the threats and the labor dispute.
No, I didn't. I was anticipating another one that you would know. Oh, sorry.
And then the SABC says that they considered these threats in a very serious light and recommended that the members report it to the police. And then they said, we'll go to a wellness center, which is ridiculous to me. I mean, that doesn't provide security. Mr. Motsoeneng and others can have security. I don't think, but I think we've covered it here by saying they made no meaningful intervention. They refer to a wellness center is not a meaningful intervention, in my view. Although they do say they considered it seriously, but they never really took it very, they didn't. Yeah, so I'm happy with the wording there. And the next one is 25.22, where I think the SABC says they're not aware of any involvement of the SSA, which would conflict with other evidence. So I think it correctly captures, just for that one slight change there, Chair. Thank you.
Should we not be, as you have always, and I say you, I'm talking, maybe you should say we, should we not be saying, notwithstanding the fact? Let's take the first one. We agreed there was no meaningful because we are putting our colors to the mast, notwithstanding the fact that there was a wellness attempt or whatever the case might be. We don't have to put it if it's not there. Yes? Because I'm trying to do what you were saying, but let's take your point.
Chair, I think if we should capture the fact that they said they can go to a wellness center. No, we should. We should capture it because it shows such disdain for the severity of journalists being physically, well, attacked and intimidated. And it makes an absolute mockery of it. So I think we need to put it in to strengthen our case, quite frankly. While I've got the floor, Chair, just on that, on 25.1.2, I think, where are we? No, 25.2.1, so where are we? 2122, where's the physical? Yeah, 25.2.1, sorry, Chair. The last sentence, the attacks and acts of victimization continued throughout most of the inquiry. When we say the attacks, are we talking about physical attacks, verbal attacks? I mean, we were told, because we were informed about one, I think Miss Fisser being physically, Miss Fenter being shot at with a pellet gun. Or air rifle, whatever it was. So I think we need to put there the physical attacks, if everyone's in agreement. And acts of victimization continue throughout. I think it just strengthens the case. Thank you.
Honorable Dr. Kosa and then Prof.
Chair, there is a point that I think we have missed under irregular, probably more on especially when it comes to the way, probably more on the dismissals than appointments. I just want to read this and members can say where they wanted to put it. That committee notes the high staff turnover, especially at top management levels, full stop, despite SABC arguing for gross wrongdoing on some of these senior and top staff management, they were all paid out. I want to bring that element of them being paid out. They are saying they committed gross wrongdoing, but all of them without fail, they were paid handsomely. They got golden handshakes. And that speaks again, this matter to me is very important because it also speaks to the financial management of SABC, but it's also about how human resources are managed at SABC.
No, I think members get the sentiment, but that's the one before. We'll go back to that, and there's no problem. Around victimization, we covered with the points that have been made now, are we? You captured those. All right, let's go back to Dr. Kosa's one. She's suggesting we include the dismissals, although they say
The high staff, first of all, it's the high staff turnover, especially at top management level. Then that's full stop. Then despite SABC arguing for gross wrongdoing on the part of some of these senior and top management staff, they were nevertheless given golden handshakes.
Happy with that? So that will be additional to 25.1. Thank you. Yes, ma'am.
Are we now moving to 25.2.2? Okay, can I just ask the following, or suggest the following? I would like to suggest that we do this, the second sentence as follows. This irregular use of the State Security Agency resources is a matter of concern, full stop. And then we start a new sentence because the two ideas don't really belong together. The next one relates to the vetting of people in senior positions. I would then suggest that we start separately with a new sentence to say, in addition, neither senior managers or in addition, the executive members and board members were not vetted as is required. Just full stop. As is the requirement, yeah. It is a requirement, yeah. So I think it's important that we just separate the two issues. The one is the involvement of the State Security Agency. The other one relates to the law.
I think that's fair. Say again? She's saying that's what she said. Yeah. Yeah, she's suggesting that, no, well, yeah, separate sentences or separate paragraphs. Are we on, where are we talking to now? Which one are we talking to? No, I'm seeing the hands. I'm thinking of the hands. Which one? You're responding to 25.2. Yes, sir. And you, 25.2 as well. All right, let's take yours, sir.
I support the new paragraph, Chair, but the location should not be here. It should be somewhere else, either on 25.1. Because it's a procedure of appointment and not a victimization or intimidation subject. Yes, the one that she's Killian, yes.
No, I wanted us to, within that line, Chair, that is proposed on the vetting, that maybe we highlight the point of a SABC being classified as a national key point, which necessitate, obviously, the vetting of senior executive, rather than just leave it there as required. You know, maybe we add in view of the fact that SABC is being classified as a national key point.
Thanks, Chair. No, I'm not bringing anything new. I wanted to write on what Honorable Mahlang was saying, to say, let's put the vetting as a new 251.3.
All right. So it will remain 2 points because the other one goes to the top to HR, isn't it? Okay. And then 26, that's 25, we can move on, eh? Thank you. 26, that's page 73, 26.11 and 26.12. So if you speak to both of them, and we'll come back afterwards to additions, if anything. Can we take Honourable Swartz and then Honourable Singh?
Chair, just at the beginning, it says, as is evident from the report presented by the Public Protector. Now, that's confusing. I would suggest it is evident from the evidence, because remember, we're now referring to the Public Protector, Mkhubani, that came before us and gave evidence that the board went to great lengths to avoid implementing. Or are we referring to the report that we got from the Public Protector and the evidence? I think it's both. So it's evidence. Because if you just refer to report there, then it's very confusing. There's the initial report. So I would suggest, I don't think you should say as is evident from the evidence, but anyway, as is evident from the evidence, the board went to great lengths to avoid implementing the Public Protector's remedial action, full stop. They instead relied on a legal opinion by a firm of attorneys which sought to trump the findings of the Public Protector. Full stop. Which sought to trump the findings of the Public Protector. In fact, it's the remedial findings of the Public Protector. Full stop. Then it goes on to say, in a similar vein, it had failed. That doesn't make sense. In a similar vein, the board failed to ensure, and then it goes on to the end of the sentence. So it's in a similar vein, the board failed. Cindy? Sorry, that's my suggestions, Chair. And then, at the end...
Whilst you're there,
yeah,
the board...
It's just to remove it.
Yeah.
Had. You just say the board
failed to ensure compliance.
The rest stays the same. With the CASA's ruling with regard to the decision not to broadcast violent protests. But what's happened now is this has resulted in ICASA laying criminal charges against the SABC. Is that not the case? There's criminal case? That's the evidence. This has resulted in ICASA laying criminal charges against the SABC. Full stop. And then the next paragraph, we just need to insert the second line, almost 2 years after what report? It's the Public Protector's report was released, decided, they didn't agree, they decided to take the report on review. So to insert the Public Protector's report and to replace agreed with decided. Thank you.
Thank you very much. You'll have another bite at it. We'll do our best to
Happiness,
capture
Chair.
it.
No, I was just saying happiness.
No, there's still two hands on the side. Prof and then, no, it was Singh and then Prof. Singh and then Prof.
Right, Chair. No, thank you very much. I agree with the amendments that are being proposed, but I have a problem with the location. I think we should, 2611 should refer to everything to do with the Public Protector's report, and we conclude it whatever we further noted, and 2612 should then refer to ICASA's, the finding on ICASA. At the moment, we are just convoluting the two things, two separate points, and then with the same content. Thank you.
Prof.
Chairperson, I was on that one. I thought the second sentence was somehow misplaced.
All right. Anything else on 26? None. 27. And as things stand, we've got 3 points on 27. So as you speak to 3 points. 27, 11, 12, and 13. Why did we... Waters?
2711, the last sentence there, it's management's contempt for Parliament and the parliamentary process, I would suggest. And then a comma is noted with extreme concern. We actually had that is noted with extreme concern in a previous version of the document. And given what we're talking about, I think it's warranted that we keep it in. The committee further notes that the minister's failure to take action in response to the former board chairperson and the SABC senior management's contempt for Parliament and the parliamentary process is noted with extreme concern, because it's a gross violation. Thanks.
Chair, it's good that we have lawyers here. I'm referring to Honorable Swati, might actually be able to assist. Under the clause paragraph 27.1.1, I actually want us to capture the fact that the SABC did not only try to to thwart the inquiry, but even when it responded, it kept on casting aspersions on this very process. It's not that they only ended there, and I think it's very important because their arrogance did not just end during that time, but even when they are responding, even they telling us, you relied on oral evidence or whatever. Thank you. No, I've seen 013, but 013 ngubonile, but I'm talking more about the actual process. Remember 27.1.3 speaks about witnesses. We are talking here about the actual process of this committee.
Yeah, oh no. Yeah. No, Chair, I think we need to reinforce that part. Firstly, I want to deal with the issue of senior, maybe we put consistent with what we have been doing. Senior managers become the executive, because executive is the one that is accountable. So we changed senior to executive. Same paragraph at the bottom. At the bottom, the board chairperson and SABC senior. I'm saying that we put executive. The point of yours is that no, that's fine, that's fine.
Chair, there's one matter I wanted to include here on the very first line of 27.11, where we talk about the culmination, and I think we should start by putting the issue of the court challenge, or either interdict or court challenge, whatever we want to call it, before even the walkout. Because I think that was the pinnacle of the culmination of their attempts to undermine the.
Covered Chair, I wanted to refer to the efforts by the SABC to get an interdict to stop our process.
No, two things, Chair. I would add, I know the paragraph is already long, but I would also add that in addition, it must be noted that the current acting GCEO was part of a press conference announcing their. No, when they said they don't recognize Parliament. That's the walkout. No, they then went ahead and a press conference. Yeah. Yeah, it's important, or is it? Yes, and call us a kangaroo court. So, yeah, but I think it's important that we must mention that the current GCEO, the acting GCEO, was part of that thing. We must mention him specifically because he affects the SABC's running going forward. Yeah. So that is one. Two, I would also mention, as an addition to the entire thing, that the current GCEO then went against the tone of this inquiry and against questionings that were done here on the appointment of Mr. Motsoeneng. He then went and appealed that court case by himself in his personal capacity. Isn't it correct? No, because there was no board chair. Even the court then said that he must go and pay in his personal capacity.
I'm not disagreeing with you. I'm just saying we must have our facts. And I'm sure that I read somewhere where it said it was an executive decision. Now, when you say in his personal capacity, I'm sure it said the executive took the decision.
No, whatever, yeah.
Yeah.
We can
So
put
I
it
just want to
whichever
be,
way.
we must be clear.
Yeah, I think the sentiment is just that we need to say that against the sentiments of this inquiry,
We can say a further challenge was lodged.
challenge of court, yes, yeah.
Okay. Doc?
Chair, I thought maybe we could qualify that by specifying that he, as an accounting officer, and also to mention that even that decision does not seem to have taken into account the financial and the reputational risk of the company, because he's an accounting officer. We wanted to hold him accountable as an accounting officer.
All right. Bear in mind that we must speak so that Cindy captures it as accurately as possible. We don't have too much spare time after this, but where we are not clear, we'll shout at you just to repeat it to us so that we capture it once. And are we still on accountability? The hands that I see? Yes, let's take Waters and then take Swartz.
Chair, I wanted to propose a 2714, if I may. It's very quick. The committee notes that in their written response, drafted by Mr. James Aguma, various misleading statements were made, which there were, and one I'd like to highlight is that they claim there was no MOI dated the 20th of September, when there was. So I think we need to put that in as well. That's my suggestion. To show, a pattern, yeah.
Chair, we need to distinguish 27.1, which was drafted as SABC's response to the inquiry. That was their physical response of walking out. We now have their written response, which is separate. The way to deal with it, you can either say that's the initial response to the inquiry, where we deal with the walking out, the court cases, and the refusal to provide evidence, and then we deal with 27.1.3, which is the written response they've given. Or we can just say response, and we deal with it chronologically, and then maybe that's the easiest. As it is there, SABC's response to the inquiry. Leave it as it is, 21.1 as amended, 21.12 as amended, but then, as Dr. Koza said, 27.1.3 would be a new section, and I just want to propose a wording that's just off the top of my head, and that would be: the committee notes that in the written submission prepared by Mr. Maguma, it casts serious aspersions against the whole approach of the committee, accusing it inter alia of bias, an adversarial tone, Motsweneng bashing, and other criticism. That just captures what is in the introduction. Then one goes on to say what Mr. Waters says, and it goes on to read 27.1.3. We need to deal with what their assertions are against us as a committee. And we need to then possibly also say the committee finds these allegations unfounded, because this is findings. So that would capture what Dr. Koza says. We need to put an introductory paragraph that deals with the approach of the SABC in both the way it dealt with the inquiry as well as its written response. We also mention in the report that we gave the SABC an opportunity to ask questions after every witness. That's also in the report. So, but I'd just like to hear your view in principle on that approach, and then I can give the word in to Cindy.
I'm looking at members. No members are violently opposed to it. No, not even opposed to it. No, it's fine. So if you can forward that to us, and we'll. Cindy's tried to capture it, but she'll compare what you've just suggested. You want to say something, Chauke, Honourable?
Maybe in the report, Honourable Swart proposed that we note in the report of Aguma. I think we have to again be consistent. I will take it that is the executive of the SABC that signed. Is the executive of the SABC that submitted the report signed by Aguma. I will take it not one as individual, but it's the executive that submitted the report. The response of the SABC. Yes. I'm saying that Swart was saying that we note the report of Aguma. I'm saying that we must expand it. Rather than saying Aguma, we say the executive of SABC signed by Aguma. On behalf of? Yeah, because, yeah.
Chair, Aguma is the acting group chief executive and he's the accounting officer, so it covers this aspect. Here, he takes a responsibility as an accounting officer of anything that happens there.
convicted, I'm fine. It's fine.
All right. Why did we have 28 in there? Do we need 28 in there? 28. 28.
No, we don't.
We just put it in because remember you guys gave us a one-pager. Without taking a value judgment, we just put the one-pager into the document. I'm just asking the question. Well, I mean, what's magical about that one? Honorable Loliwe?
Thanks, Chair. Chair, to me, is not adding value, so we can live without it.
Agreed? No, yeah, okay, you'll start Waters, then we'll go to Mukwena. Anybody else? On point 28. There's only one point on 28, and we're just asking the question, what value is it adding?
Well, Chair, it highlights the fact that there was an erosion of, a gradual erosion of editorial independence and expectation of self-censorship at the SABC. And that the 28, eh? Am I on the right? Am I? Oh, sorry, I'm looking at yesterday's. Sorry, I'm looking between the two documents. Sorry, Chair. All right, because I made notes on last night's one, if you remember. Okay, I'll come back to you. Sorry, Chair.
Yeah, Chair, I think, yes, I would have commented on the nature of the evidence that was given by Dr. Ngubane to this inquiry, because much of it was unreliable. My worry is that is it central to the mandate that we have here, and that's the only thing. Apart from the fact that this is a civil servant who, yeah, no, leave it. It's fine. There's no problem. I'll argue it in Parliament.
Yeah, do that, because yeah, no. So the agreement is we take out 28. Thank you so much. The 29 on page 75.
Which one?
29.
Chairperson, I would like to suggest that the only amendment we make is to the last component of that paragraph, and that we refer as follows. The board had therefore failed in its responsibility to ensure the SABC's compliance with the provisions of the Broadcasting Charter, which has undoubtedly contributed to the SAB's loss of revenue and declining, I don't know what you call it, listenership, but there's also a viewership. So do you say declining client base to capture both? The point that I'm just making is that we've got a declining revenue, loss of revenue, but also declining client base, which has consequences on its own. But the reference, I'm just changing a little bit with regards to the Broadcasting Charter, because that is a very important component. It's one of the specific responsibilities of a board, is to uphold the Broadcasting Charter, which includes news independence and all of that.
Can somebody remind me what sort of evidence do we have on the listenership? I understand the SABC's loss of revenue, But the listenership, what sort of viewership, what sort of evidence do we have to that effect? Because I'm not sure if there was something that was presented to the committee that speaks to the evidence in as far as that particular aspect. Remember, we have to make sure that our report as well is credible. We mustn't invent things that we mustn't be speculative.
Thank you, Chair. The question I want to ask is we received evidence on loss of revenue and declining client base. For want of a better word, I'll say client base. But that wasn't caused by editorial independence. That was caused by the revised, in the main, the revised local content policy. That's what led to it, not the editorial independence. Right? And then I don't see the need for the second sentence on page 75. The SABC employs a core of highly experienced, highly qualified and dedicated journalists. I don't see how that fits into the kind of observation we're trying to make. The observation we're trying to make was that journalistic ethics was compromised. Then there was a gradual erosion of editorial independence and expectation of self-censorship. Then we also got to make the point about the revised local content policy, which led to loss of revenue and declining listenership. So I think we've got to bring that aspect in. Thank you.
No, Chair, just to point out that the SABC 8 did allude to the SAFM, I think, where a program was canned completely. The editor had said to them that they must can that because of some political whatever issues. So I think there is there's a case to be made about, and they did say that they lost listenership because of that decision, and that was just an example. They were making an example of it was a microcosm of a much bigger problem. Thanks, Chair.
Chair, as a middle way, because to me, we had the SABC 8 that gave us that oral evidence. My main concern is that I'm just saying probably instead of putting the loss of revenue is something that we can also prove, because you can prove it. But maybe when it comes to the listenership, maybe we may say contributed to SABC's loss of revenue and may have also led to the decline of, to a decline in listenership and viewership, or whatever the word, or client base, or something like that. May have, because we don't have empirical evidence. In other words, we're taking what the SABC 8 said, and obviously they have, whoever that is going to be taking this process forward will then have to check, assess, to what extent did they lose the listenership, because obviously the revenue is a sufficient indicator to suggest that they may have lost the listenership as well. But we don't have sufficient evidence in that regard.
Yeah, Chair, just to confirm what Honorable Khoza is saying, I have a document here for what it's worth. He's saying partly to blame is Motsaneng's unilateral implementation of a 90% local television quota, which has hit the broadcaster hard. Figures show that the resultant new schedules had an almost immediate effect, with profits on SABC3 down by almost 35% in July 2016 after implementation and continuing to slide. SABC insiders say that in October 2016, SABC3, historically a big money spinner for the broadcaster, posted a loss for the first time, with the channel meeting only 50% of its advertising quotas. Audience share is dropping month by month on both SABC2 and SABC3, according to insiders. So I think that just confirms what you're trying to say. But it's not only related to the program content and quota, but it's related to other issues as well. Thank you.
Chair, just briefly, I want to support Honourable Singh and Honourable Dr. Khoza. So, to do with that the last sentences where it starts with the board has therefore failed in its responsibility to ensure that the SABC's compliance with the standards set out in the broadcasting charter, right? Full stop. So that's one issue. And then another sentence, in addition, the 90-10 editorial policy has undoubtedly contributed to the SABC's loss of revenue, and then what Dr. Khoza talked about, and I think she said possible declining viewership and listenership. Did you get that? Okay. All right, thanks.
Honourable members, that deals with journalistic ethics. Is there any other additions in journalistic ethics?
I just wanted to make sure that we are now removing because Honourable Waters repeated standards, and I was suggesting that we go with provisions of the broadcasting charter.
All right. The last one was parliamentary oversight. So you're all guilty as charged? All of you? All right. Okay. No, we know your view, yes, yeah. Yeah, we know your view. All right, any additions to that? Any other additions? Other additions, is that it now as far as findings, stroke, observations are concerned? And, oh, no, there's the MOI, I beg your pardon. Yeah, when we get to the MOI, Honourable Swartz, just apply your mind. Honourable Swartz? No, I'm just saying, just apply your mind. I think it was before you came in. We were debating whether we call it findings or observations. Later you'll tell us, that heading. Okay, we had some debate, and I'm asking you because you seem to be our expert in that regard. Before we left, we had asked Mokoena, the Honourable, to try and craft an observation around this debate that we've had for the better part of 2 days. I'm assuming members have had it and have had a look at it. I don't think Mokoena should talk to it. You'll be the last after members have commented if they want to, sir, unless members want Mokoena to talk to it. Okay, then go ahead and explain. We'll open it up for members, and then we'll take it from there. Sir.
No, I just thought, sir, Chair, that we should have a section that just deals with the paperwork but this is paperwork that lies within the jurisdiction of the minister. It's the MOI, it's the directorship. Obviously, we can change it and whatever. But these are the sentiments. And then I think it's also important that we must look at the current MOI and how it affected the SABC. So we must not neglect that. And this is the reason why I then said we should have 23.2, and that must speak specifically to the current MOI as it stands, because we must examine it. It's going to be key in how we judge what happened at the SABC. Thanks, Chair. No, 23.1.1 is as in the original document now. I'm suggesting that 23.1.1, 1.2, 1.3 remain, but they become 23.2.1, 23.2.2, and 23.2.3. And any other additions that we may discuss going further now.
Yeah, I guess the point I'm making, if you read that last sentence, it seems to stop halfway. Made the following observations. on the minister's MOI amendments, and he doesn't, who's going to make those observations?
No, the observations are, if you look on page 70,
On page 70, just say it to us slowly so that Cindy captures it. On page 70 of our document,
yes, of our document.
right?
On page 70, on 23.1.1.
Oh, I see
So
what you're
those
saying.
ones remain, 23.1.1, 23.1. So there's no change to the document there.
Oh, okay.
Yes.
All right. So members have followed it. As long as members have followed the explanation, we'll then open it up for discussion. If there are, we'll start with the Honorable Khoza. We will then go to Honorable Killian. Honorable,
First of all, Chair, let me confirm.
hold on.
Okay.
Khoza, Killian, Singh, Chauke. Did you want to speak, sir? Yes. And everybody wants to speak. All right. Then let's start here. Chauke. Eh? No, but it's going to be 3 minutes.
Yes.
It's going to be, and we'll just go this way here. Please put your mic off.
Are we entertaining Mokwena's? Okay, Chair, I'm not necessarily opposed to his suggestion on 23.1.1 from where it starts an inquiry into the IPC revealed questionable enrollment of both Mr. Motsoneng, but we must add there as directors. But I think that first part, the shareholder failed to administer SABC founding documents effectively. To me, it's just very vague. I don't think we need that. Because it's not she's not irresponsible for managing documents. So I'm saying it's unnecessary. Let's rather start from where it starts. An inquiry into the CIPC revealed questionable enrollment of both Mr. Motsoneng and Ms. Geldenhuys in 2011 and 2012 respectively as directors of the SABC, when there appears to be no plausible explanation for this action.
I was going to suggest, Chair, rather than using the word at the 3.12 failed, and we use did not register, because the fact is that, she did not register the amendment rather than failed to register. I thought we used the word did not register. We changed failed to did not register. I think it's 1 and 2.
Okay. Cindy's indicating that 23.1.2, Honorable Mokwena, it's not in 2015, it's 2014, right? You see that first sentence of yours that says MOI in 2015, it should be 2014, but you'll come back and after all comments. You'll just note what honorable members are suggesting, and then Chauke, one man, one bite.
Because Honorable Mokwena proposed that we remain with the 23.1.2. I want to propose that we remove the word at 23.1.2, irregular amendment, to put attempt to amend. We use the word attempt to amend than irregular amendment, because that was not amended, it was an attempt. Because if it was amended, it would have been launched with a CIPRO then.
Thanks, Chair. Chair, I'm looking at the documents submitted by Honorable Mokwena. I am not sure when I look at the submission. It is just another way of stating what is already here. So when he goes further to say we retain, the bullets that we have is creating a bit of confusion. And also we remain as people that are conducting an inquisitorial investigation, if I can put it that way. So when we start by saying the shareholder failed, the minister failed, for me, we are not there as yet. We are just outlining our observation. We are not saying we conclude the following from our observations. So that's why I said, if to me he can indicate what was his take in what we proposed there, because we said for the MOI to say which one is authentic, remember the decision which was put forward was to say 23.1.4 states or levels the ground so that nobody is confused on an active MOI. The use of a document that has not been submitted to CIPRO, to me, it is the irregular amendment. I need further convincing, Chair, for me to buy into this and to believe that they mean something different from what is captured here. It's just a matter of semantics. Otherwise, I think we are saying the same thing. Thanks.
Yes, thank you, Chair. Can I just suggest that I agree with Honourable Khoza that it's not the Minister's responsibility to administer the founding documents. I would suggest that we remove that first introductory sentence and that we actually, since we have moved 2.1.4 up, we just put this next sentence, a further scanning of the CIPC documents revealed the questionable enrollment of both Mr. Motsoeneng and Ms. Geldnys in 2012 and 2012 respectively, when there is no plausible explanation for this. So that we capture that as part of the CIPC documentation. Then I think as far as the second paragraph is concerned, we must just stick to what is really the essence of it, that the Minister didn't, contrary to what the Minister said, it appears that we have not found evidence, and I think we've already captured it there. And then the last one, I would argue that that one is important, and that is that the Minister, again, the Minister and the SABC board allowed a delegation of authority framework based on an invalid MOI to be the regulatory platform of the SABC. I think that is very important that we keep that. This rendered almost the entire operations of the SABC legally questionable. Yeah, I would support that we maintain that. But I don't think it is not the shareholders' responsibility to administer documents. According to the MOI and according to the Companies Act, that is clearly the responsibility of the corporation. Thank you, Chair.
Oh, I thought you were responding.
Thank you, Chair. As far as paragraph 2312 of Honourable Mokwena's document is concerned, where we say the Minister failed or did not register the amendment to the MOI, we have proof of that. We've asked for the proof. There's been, for any proof of the MOI being submitted, and it hasn't been forthcoming by the Minister or the SABC, so she hasn't done that. The next sentence says it must be noted that the Minister made a written submission that such was registered, which is true. It's factual. Factual. And that is in 912 in our document, right? The other issue is not factored in, and I'm looking for guidance, Chair, where it would be suited, and that is the fact that the Minister states that she took it to the board and there was no objections to it. Meanwhile, the minutes prove otherwise. That's got to come in still. 2313, that paragraph, I fully support that it must stay in as is. the DAF is vitally important to show how the invalid MOI was used to abuse the system. Then there's one other issue, Chair, and I'm also, it's got to do with the working document. Now, I don't know if this is correct. I was hoping to get the original working document, right? Where I raised it yesterday. In paragraph 12.2, it says, during the testimony, the minister denied that she had signed the MOI. Now, if that's the case, if she did say that, and I think we need to look at the transcripts again, right, to verify, because if she hasn't said it, obviously mustn't go in. But it's in this document. The working document, it's the very first one we had, right? The fact is, if she did say that in a testimony, and yet contradicted herself by saying she submitted this MOI to the relevant authorities, then that's another contradiction. Okay? And if that's the case, it's got to go in here somewhere, please.
When are we going to check that?
I don't know.
Thank you, Chair. A couple of things. Firstly, I'm not too convinced on the headings, administration of SABC founding documents and then weaknesses, because I think the issues are correct. One refers to the directorships. The one statement refers to directorships, and the other, I think the content of everything else refers to the MOI. So I'm just putting that before us about, whether it should be directorships and MOI. As far as the directorships are concerned, as I might call it, point 1, I agree with Honorable Khosa's submission there, which I think you've captured. And then on the question of the MOI, I still feel that we should start with what we had in our document on 2314. Right? Yeah, we start there. Then we don't make a categoric statement that the minister failed to register the amendments to the MOI as the opening line in the next paragraph. We should start with her evidence. During her evidence, the minister insisted that the amendments were lodged with the CIPRO, with CIPRO, right? Yeah, it's here, page 36. Yeah. I'm looking at page 36 here, during her evidence. Yeah. That's what she said, during her evidence. During her evidence, the minister insisted that amendments to the MOI were effected in accordance with the Broadcasting Act and Companies Act. She stated that although legislation did not require her to do so, the ministry had consulted the board on the amendments as a courtesy before they were submitted to Companies and Intellectual Property Registration Office. She also briefed the Portfolio Committee. That's what she said. But the only evidence of that is this document here, which we've got to refer to. Document dated 12th March 2015, which I think in our view is a non-document. And I think we've got to state that. So what we are doing in effect is we're discrediting the assertion that this was lodged with CIPC. Right? And then thereafter, I agree with everything else that we've got here. Thank you.
Excuse me. Thank you very much, Chairperson. Let's thank Honorable Mkwena for his contribution. But I really have some doubts as to whether it brings any new information, my learned friend, whether there's any. I think it somehow adds. It somehow adds to what we have, but the contribution is really welcome. For instance, Honorable Mkwena, you see administration of SABC founding documents. The Honorable Khosa stated quite succinctly that that is not the task of the minister to do that. And you have used the word enrollment, questionable enrollment. I doubt whether that is the right word or whether we should be using the word listing. The concept of plausible explanation, why plausible? going further down, I've got a statement that says this renders the minister's MOI not enforceable. Yeah, I don't think we're there yet. Further down, you use the concept regulatory platform. There would have been another word for that one, rather than platform. But the contribution is welcome, Honorable Mkwena. But I should think what we have here, we must have a way of trying to locate the stuff in what we have here. That's my contribution, Chairperson. I see colleagues. I'm congratulating my learned friend here, Mkwena. I'm done.
I align myself with the sentiments expressed by my colleagues. I think the document on the last paragraph that we've lifted up, if that is married with the last part of Mr. Mkwena's input, it would be fine. And then the second paragraph, well, I guess colleagues have already corrected as to how it should be crafted. And instead of registering, we use the word lodging with CIPC. And then the last paragraph that he's crafted, I think it's fair. The heading, obviously, I think colleagues have already expressed themselves. I can't agree more. And the last, the 23.2, I think will not arise because already the one that we've lifted in our own document 23.14 covers that quite well. But I would want to say, Chair, I do not know whether we have somewhere reflected on the four MOIs. Because we've got four, and I do not know as to who owns what, because I know that the first one is one which was lodged by Minister Karim. There's another one which the minister said was crafted by her successor. I don't know whether it was Ule or whoever. And now we must actually try and manage where we've used people's names, and we may use people for even unrelated matters. So we must just be very careful.
I thought the debate about the 4 was done because we started with 23.4. I thought it was done. We had said, look, let's not have this debate. Our position is the one. I'm not disputing, but I'm saying I thought that's what we'd agreed upon even yesterday. So I don't want us to reopen it
so
again.
So it doesn't...
Very confusing.
Eh? I'm not saying you're wrong. I'm saying that to Mkwena when he responds to us.
Because I'm worried when we allocate a lot of MOIs, it creates problems unless I'm just saying I'm raising the matter, Chair, because it does arise here. So if we have to, then we have to go through that process. But I'm fine with what we have without really going into the other breakdowns of whatever. Because we refer to something that we don't recognize, yet we said that we don't actually accept it because it doesn't exist. But once we refer to it, then I think that's where we open ourselves up.
Honourable Swarth?
Chair, I think we need to get a draft because there's so many different versions now of amendments to Mr. Mkwena's suggestion. So we need to get a draft because my concern is firstly in the first paragraph, that sentence, when there is no plausible explanation for this action. Now, in all the evidence, this is we haven't referred to this at all in any of the interim document about that. And firstly, the word enrollment should probably be appointment, the questionable appointment, respectively, as directors, when there is no plausible... Well, we've never raised this issue before. So we would need to obliquely maybe say there, as there does not appear to be an acceptable explanation. But we haven't dealt with that at all anywhere. So we're raising a new issue there. The next paragraph I'm happy with, subject to what other members have said about the repeating about Minister Karim. The last sentence, this renders Minister Muthambi's not enforceable. I'd say not legally enforceable. The next paragraph where it says illegal, I would just say it is based on an unenforceable, legally unenforceable, or invalid. Or invalid is even better. And then this, now the last sentence is huge, because it says this rendered almost the entire operations legally questionable. So, and it's again taken a strong stance, but the implications of that statement, maybe one needs to just downtone it. This appears to render almost the entire decision-making of the SABC legally questionable. Because again, do we really want every decision of the SABC to be contested in court? That might be the implications, but are we 100% sure of our facts? So, and then when we deal with 23.1.1, it's the reference there to the MOI must then be to a specific, the MOI dated as it stands purports to empower the minister. Now we're dealing with the illegal MOI. We can't just leave the wording as it is in 23.1.1. Again, the irregular, and I think Mr. Chauke earlier said the attempted amendment of the MOI dated so-and-so. So we need to tie it up. It's very complex now because, I mean, Chair, you must be struggling, I'm sure, Cindy's, because there's so many suggested change. We need to get a version that we can look at again, I think. I think Mr. McQueen has done very well in giving us a working draft on something we've been struggling with. But maybe we should just stop for 5 minutes and just get a version that we can all look at, because you've got so many different versions. Thank you, Chair.
I've never been so challenged before. I really have never been so challenged before because you know, honorable members, and let me speak for myself. What I would want to see come out of this whole debacle is the regularization, ratification, whatever you want to call it, around the MOI. At the end of the day, that's what we want to see. So, in my own head, my recommendation is going to be whoever the authority is must look at this whole debacle and sort it out. Now, we are cracking our heads about all these other things, and I'm not saying it's right or wrong. I'm just trying to find a deadlock breaking mechanism. Is it, and I hear what everybody else is saying. Would it not suffice if we say that in our observations this thing created all sorts of complications and potential, whatever the case might be, in our observations, and we'll find a way. And then in our recommendations we say the board or whoever the authority is must speedily sort this thing out. Because I think we've had about 5 versions of what we want to put in and take out of this thing, and we're never going to reach the end of it. We're just not going to reach the end of it at this committee level. So I'm just, and there's no, and because we're all speaking the same language, we're saying this thing has been a mess. We're all saying the same thing, it's going to be a mess. It's about emphasis, I think, that we're arguing about. So my firm recommendation is let's find a way of saying our observations show in no uncertain terms that the entire management of the MOI has created serious, because remember our mandate is to take the SABC from where it is now to a better place, as opposed to pointing a finger as to who did wrong and who did right. and I'm just talking on this one. So I'm saying in my own head, at the end of the day, I'm going to argue that we must say that whoever it is, I haven't even thought about who it is, must deal with this thing as soon as possible. Like we said with the amendment of the supposed amendment of the Public Broadcasting Act. We just said whoever it is, make sure it covers these things. I honestly, on members, and this I'm saying with total transparency, there's no ulterior motives on this one. Can we not, because I'm now really at a point, honorable members, where it can't carry on. This one can't carry on the MOI, and I'm just saying that we've identified it as a problem. It has serious ramifications. Mr. or Mrs. X, whoever they are going forward, look at this thing as a matter of urgency. Because I see, at least here now, besides what we've put in, two other documents talking about, around, all of us saying the same thing. We're not disputing what we are saying. How do we marry these documents, or do we vote line for line? I'm seeking your guidance. Because all of us are saying, and it's not one minister, this thing has historic links. And for us to take the SABC to where we want to take it to, let's recognize that it was a problem historically. We recognize the one that is, or we can prove that the only one that's registered is the Karim one, with all its weaknesses. And we're looking forward to the new interim board fixing it up. I'm just trying to get there because even now when we were debating, everybody was challenging everything else. And Mokoena, it's unfair for him to have done this in 5 minutes. I don't know. I'm just asking for guidance on this one. But we really are stuck. Otherwise, we must can it and look at it again tomorrow. I'm just scared that it's from 8 o'clock. This is where we are. And we're dealing with one matter that I think we're overcomplicating. But let's listen to Mokoena.
No, Chair, I agree with you 100%. I agree with you 100%. And I agree with the changes that everybody is suggesting, because I think they're quite valuable. But yeah, let me go through the changes as they are suggested. One, I do think that it is the responsibility of the shareholder to make sure that the documents of the company are in order. You can't run a company and the director there is a criminal, somebody who's going to put the company in jeopardy and so on and so forth. It is the responsibility, but I am not hard and fast on it. If you want to take out the issue about the shareholder failed to administer founding documents of the SABC, you want to take that out, that is fine, because the heading will speak to it. And I agree that that we should rather say that an inquiry into the CIPC revealed questionable what was the word? I think it was appointment, yes, appointment of both Mr. Mutsuening and Mr. Geldenhuys as directors. I agree with Makosi there. Respectively, when there appears to be, I agree with that, no plausible explanation for this action. I agree with that 100%.
Everybody agrees with that?
Yeah, we are there now.
Yes? So we can cut out that first sentence and then we can clean up those other ones, right? I do agree that, okay, so we didn't seem to have a problem with the second one, I think.
We did have a problem with failed. Others said have not provided evidence. Some said failed. Some said, that's the point. Just that word failed.
Oh, well, I don't know what the problem is there. Again, I'm not too hard and fast on it, but I don't know what the problem is because the fact is she failed. My point, Chair, is that she did fail to register. If she passed to register it, we would have evidence that it's there. It's not registered. Therefore, she failed to register it. It's a fact. We can't change that. So if you want to look for a synonym of failed, that's fine. but she did fail. Right?
Hold on.
Yes?
So that we don't come back to it. I think we must go word for word on this one. I mean,
Yeah, no, that's fine.
we've agreed on the first paragraph. The second paragraph, what is what our members saying on it? Let's kill this thing once and for all. Just read the second paragraph as you are suggesting it. Members will go through.
No, the only changes I had on that one that I heard were the 2014 is correct, yes. And it must be noted that the minister had written a submission. That is also fine. In fact, can I recommend a change to the sentence? I would add in that sentence, so it would read, the minister failed to register the amendments to the MOI in 2014. It must be noted that the minister made a written submission that such was registered, but according to CIPC reg, so we add a but.
Or however.
However, yes. However, according to CIPC records, the last MOI to be registered was in 2013 by Minister Karim. This renders Minister Muthambi's MOI not enforceable. Or not legally enforceable, that was the correction, yes. Right?
That's a fact. It's a fact, yeah. It's a fact. Yeah.
Yeah.
So you want to talk to that on that one? All right.
Chair, I don't know how to handle this, but I'm worried about us trying to manipulate evidence to drive us to a particular direction. And I just want you to hear me out what I have written. Whether you agree with it, if you don't agree with it, check it out, it's fine. But I'm saying, the committee found that there were at least 4 MOIs. However, only one was found to be registered with CIPC, dated March 2014. Full stop. Notwithstanding the above, even the registered one appeared to have sections that contradicts the provisions of the Broadcasting Act. That way, this leads us to the recommendation later on, where we are saying this issue of the MOI must be sorted out. Because you are therefore killing all the other unnecessary detail, because we are now trying to manipulate evidence, and I don't think it's the intention of this.
Chair, we'll have to leave for about 2 hours on Saturday afternoon to go to Honourable Van Dam's wedding, but that's about it. Okay. Chair, in relation to paragraph 2312 of Honourable Mokwena's document, I don't think anyone is trying to manipulate evidence. There's clear evidence, undisputed evidence, that the minister, and it's in our documents, and I refer you once again to paragraph 912, page 36 of our document. Yeah, not yesterday's one, today's one. I've put that one to one side now. Right? And I will repeat, I'm going to read it out again, just to, right? During her evidence, the minister insisted that amendments to the MOI were effected in accordance with both the Broadcasting Act and the Companies Act. She stated that although legislation did not require her to do so, the ministry had consulted the board on the amendments as a courtesy before they were submitted to the Companies of Intellectual Property Registration Office, CIPRO. Right? Now, she never did that. So right. In addition to that, we've got evidence from CIPRO itself that the last time anyone had submitted anything was Minister Karim, right? And and it's also backed up by these two documents, CRR 14.3 and CRR 39. And then in addition to the document we got today, this one, which none of us believe is actually authentic, right? So the minister failed. She did not submit the MOI like she claimed she has in her testimony. So what Honourable Mokwena's sentence is saying is that she failed to register it or submit it or whatever, or lodge it, whatever anybody wants to say. But it doesn't change the fact that she failed to do it. So I don't think anyone is trying to manipulate evidence here, Chair. All right.
Yes. No, I'm accepting that. I think we're getting stuck, and I don't have a position one way. Some people, and I don't know where's Mr. Swartz. I'm sorry he's out. We seem to be stuck by this word failed or have no evidence before us or whatever. Members feel strongly that says the evidence is there. We're not disputing the broader context. It's about how you're putting it, I think, is what we argue. Now, that's what but just on this one, eh? Yeah. All right. Do you want to? No, but then you're going to open up another debate. Let's deal with this one first. Let's start here then. Let's take, you'll be number one, Prof. Yes, sir. Number one, Prof. It's just the two that want to talk to it.
Chair.
Yes, and you'll be number two, Doc.
Chair, on this particular issue, we have spent a lot of time giving facts that correlate. And if we listen to one another here, you find that the information we give could be sometimes a matter of semantics, but we are saying one and the same thing differently. I was of the opinion that the Honorable Dr. Khoza is trying to simplify what is before us, because anyone reading the document should get facts, but in a simple way. So what Honorable Mokoena gave us is relevant, but we should put it in a simplistic way so that everybody would be able to understand it. That's my take, Chair. Otherwise, we'll circumlocate one and the same thing till morning.
I just wanted to come with a compromise position, if members, if they can listen carefully, because I want to, to improve on what I said earlier on. I think probably we can say the committee found that there were at least 4 MOIs. However, only one was found to be registered with CIPC, dated March 2014, during Eunice Karim's tenure. Full stop. Notwithstanding the above, even the registered one appeared to have sections that contradict the provisions of the Broadcasting Act. Then, full stop. Furthermore, the inquiry into the CIPC revealed questionable enrollment of both Mr. Motsoneng and Ms. Geldenhuys in 2011 and 2012, respectively, as director, which appear to be grossly irregular. Then the next one, full stop. Then we say, the minister Muthambi, Faith Muthambi, failed to register the amendments. I mean, the Minister Muthambi, one of these other MOIs, because we've already said there was one that belonged to Karim, but we are now speaking specifically about Muthambi, failed to register the amendments to the MOI by 2015. And that it must be noted that the minister made a written submission that such MOI was registered. According to CIPC records, the last MOI was registered in 2013, or whatever was registered in 2014, because we've already said that it was during Eunice Karim's tenure. And to me, I think that you've captured the essence of the key issues, because to me, the key issues that seem to be contested to me is that, one, we wanted to be explicit about, if I hear you correctly, is that the Minister Muthambi did not or failed to register the amendments to that MOI of Eunice Karim. And two, we also wanted to to put forward the information about the what do you call it? The enrollment of both Mr. Motswaneng and Geldenhuys as directors. I think we wanted that to be there because we see that as being grossly irregular, if owing to the times in which they were appointed and whatnot and so forth, and their capacities and so forth. So, Chair, I was trying to cover those key aspects that were contested, and I'm hoping that maybe this assists us in getting out of this challenge.
So, Chair, primarily what Dr. Khoza is suggesting is that we keep the document as is, but add, and I agree with her, that the MOI as it stands now, as it is now, contradicts the Broadcasting Act. That's what she's... That's exactly what she's saying. So that's the only addition that she's made to this thing. So which would then, my only contention is that the third point, 2313, speaks to the delegation of authority framework, which is the document that ran the entire SABC. And this is the source of all the problems that we saw there at the SABC. So I would strongly contend, but if I'm defeated by the numbers, I will think. But I strongly believe that we need to keep the sentiment in there. Yeah. But in essence, I agree 100% with everything that Dr. Khoza has said, without any conditions.
I thought that 2113, we were almost there. I think we just took out illegal to invalid or questionable, and then somebody spoke about the very last sentence.
Yes.
But I thought we were almost there.
Invalid. Yeah. And then the last one was...
No, I'm just talking before that one.
The last sentence in that one.
Oh, you're talking about the last sentence in that one,
Yeah,
yes?
the last sentence, which...
The one that starts with this.
Renders, Ms. Muthambi's thinking invalid, not... This renders Minister Muthambi's MOI invalid. Oh. No, I was just changing the last two words.
If I may?
I was reading the wrong one.
In 23.1.2, the last
We're taking what Dr. Khoza said.
No, yeah. Oh, what?
We're taking the proposal that Dr. Khoza made.
On the Broadcasting Act. Yes, on the Broadcasting Act.
For 2312.
That is correct. The addition that it was not in line with the Broadcasting Act.
Yes. You've got that in there, Dr. Khoza.
Yes.
In your one, you've had that one.
Yeah, we need that addition.
Which one?
The one that you mentioned about the current MOI it contradicts the Broadcasting Act anyway, yes. I agree with that.
And
I was saying, maybe what we can say, you know, your 23.1.3, we needed to say possibly the unregistered MOI, then in brackets, Minister F. Muthambi, appears to be at the core of the many related governance problems, including the delegation of authority framework document.
That's fine.
Is that okay? And, yeah.
That's proper.
Yes, so I'm saying, yeah, I was just saying, that way, if we specify that the unregistered, in
Yes.
other words, and we put in brackets,
I agree.
Still have a second by tomorrow anyway.
then you don't have to be using all the other wording that you have there.
Sure.
Let's please write it so that we capture it. Yes, so that we capture it. We'll have another bite at it tomorrow. I am not opening it up again. You'll have another bite tomorrow, Honorable. All these pieces of paper that we have here, tear them up, throw them. We'll have a debate on that one tomorrow. It's going to confuse us.
But
on
Chair,
this one.
I think your point, the point that you raised is proper. I think we must add, as an addition, when you do your thing, to say that the MOI has caused all kinds of problems. I think we need to say that. Yeah.
We can add that because ultimately it's about getting us to a better place. All right, honourable members. I'm looking at we fought with our support staff because transport wasn't on time and we had to wait, and they need 2 hours notice. It's 10 now. I'm hoping that the next session doesn't go too long. What time do we tell them to be here? Because if you don't give them 2 hours notice, they're not here. I'm talking about the transport. 12:15. I'm looking at, you shaking your head. We told you that yesterday. Siyalala siyavugala. I'm looking at where is Mabasutu. No, that will be the absolute worst, I'm saying. I don't think it'll be that long. We've had such a big debate now. Recommendations should really be smooth sailing in the main. Because people already will start walking out and coming back. Yes, sir.
Just on the MOI, support all the recommendations, but the other points I raised, are they going to be in somehow?
No, that's what I was asking. We can do, I'm saying at least we'll have the
We'll
framework.
look at it tomorrow.
Yeah, I think your point where it says Minister in her input said she has done it and she hasn't proved it. That's one that might not be there, but we can add that one.
And then no disagreement with the board agreed with it, meanwhile they didn't. That's
Yes,
going to...
I'm saying even if it's not in that one, there was no disagreement with
thank
those
you.
because we've got evidence to that effect.
Okay, no, just checking. Thank you, Chair.
Yeah.
Thank you.
No, I think that's valid. Let's bed that one down and we'll add the 1 or 2. Is that okay, honourable members? You really want to say something? Yes, ma'am. But look.
All I wanted to
No,
say,
hold on,
Chair.
before you speak. What I'm saying is, you're just going to make a comment. We're not even going to respond to it because the document is going to come tomorrow. We're really talking from the dark now. We'll hear you and we'll hear you on that matter and we'll take it from there. Right.
Person, what I just wanted to say is we devote a lot of time about what went wrong with the lodging, etc. But we do not take from the documents at our disposal the critical matters that are actually our concerns and which supports our notion that the minister's intervention in the MOI was to strengthen her interventionist role. Now we can shorten the comment, but all I did, and that is the document that was submitted, was just to give the background. It's too long, but it's just the factual base that we can consider one paragraph tomorrow. Thank you, Chair.
Now, I was going to do the new process. I'm done with that part. I'm fine. I'm very fine.
Can you? Or you understood the side?
Yes, but I need to, yes.
Okay. Cindy's asking because she needs to sit this side and charge her phone. Can there be a 5 minute, not a phone, a laptop? And it's close to that side. Just 5 minutes so that we shift around. 5 minutes break and then we come and deal with recommendations. You want to sit this side, Cindy?
Is the members' facility open?
5 minutes. Yeah, 5 minutes. You want to sit this side? No, I don't drink tea and coffee. Is there an issue, I mean, is there a reason to discuss the way? I don't want to fight on it, guys. Let's go to the, you know, if they don't make logical sense, it's fine. But let's just deal with them. It's okay.
Exactly,
Your slap date is weg.
Hold on. As long as we can get to the recommendations, then we go.
Where are the recommendations?
Just check that everybody has this document.
Honorable. We have not provided breakfast for you, so you better make sure you are able to go home for breakfast. Yeah, no. Exactly. Yeah. All right. Yeah, exactly. All right, whilst you're doing that, honorable members, you should have an interim report, ad hoc committee recommendations, part F, at least. Let's just ascertain if everybody's got that document. Everybody's got that document. We don't need to run copies. Yes.
Which document?
Something that says recommendations, part F.
Oh, yeah, I think.
Honorable Chauke.
No, thank you very much, Chair. I'm just taking it from the last meeting where we agree on the process as to how we should deal with the last phase. For that note, Chair, I was maybe proposing that the way forward being that of getting from the colleague that we were tasked, that we have agreed that we share, this recommendation as to how she has managed to package them. Maybe we deal with the packaging first, and then from there we can then begin to look at the recommendation each. No. I'm saying that in the last engagement of the committee, that on recommendations, we agree that we should share information with regard to what Honorable Kellen has sort of prepared with regard to the packaging of recommendations. I was proposing that maybe as we start, Chair, we begin by maybe allowing Comrade Kellen, Honorable Kellen, to sort of guide us as to how she has managed to package them. You remember, this point is about the long-term, the short-term recommendations. Maybe I'm therefore saying that we can then take it up from that approach maybe, which is easier, and it will help us, in fact, to speed up moving forward with recommendations.
Yeah, Chairperson, no, I agree. Then if that is what we are going to do with your authority as a chair, then we have to make sure that everybody has got hard copies of what she proposed. I mean, it was sent to, I've got it, I don't know if everybody else, because from what I see in what she has proposed as the formatting, it makes a lot of sense. The way she has formatted it, it's logical, it's in headings, and then all we would need to do is to see if there's any omissions and then take it from there. But the way it has been crafted as a draft framework, I'll call this a framework, let's not look at the contents, seems to be quite in order. Thank you.
Okay. Chair, I'd like to support what Honourable Singh said. Honourable Killian, and thank you very much for all the work. Killian, I'm getting mixed up with Sandy and everything. It's very late, sorry. Did a lot of work, and I think the layout is quite logical and assists us all. I don't know if you've all read it, but yeah. But I think if we could use this as a basis, it'll be as a the groundwork, and we can build on it. That'll be great.
The obvious question is, has everybody... Okay, Doc?
You know, I did receive Honorable Killian's formatted document, but I don't have my iPad with me right now, so I don't have access to it. Can we have the hard copies, if that's the document we're going to be working on?
Means going to my office, I'll go. How many people don't have hard copies? Yeah, that's what we just need to check. How many members don't have hard copies? 1, 2, 3, 4. 4 members. 4 members. Just grab one from anybody. Take Killian's one and make 6 copies. Is that okay? Take that one from Killian and make 6 copies. It means, honourable members, we'll have to take another 5-minute break while we make copies. Is that okay? Is that okay?
Except no, we're not going to have it in.
No, honourable members, no, but my office will have it in cover. It will be in cover. Will it be? Okay, honourable members, the only disadvantage is that it's not going to be in colour. Is that no problem? Okay, make 6 copies, 6 copies.